Court Department. Hear ye, hear ye, hear ye. All persons having business before this court will draw near to their attendance, and they shall be heard.
Thank you. Please be seated. First case on the calendar for oral argument is number 824, People versus Brundage.
Good morning.
Good morning.
May it please the court, Paul Curtin on behalf of Caleb Brundage. I'd like to address my comments this morning to the Huntley hearing and the results therein. Excuse me. The Buffalo Police Department towing policy in this case required that the owner of a car to be seized be offered the opportunity to have the car towed himself. That was not offered to Mr. Brundage, and therefore the very decision to impound the car was unlawful. In addition, once the decision to impound the car was made, the Buffalo Police engaged in a very incomplete, selective inventory of the items in the car, as admitted by the Buffalo Police during the Huntley hearing and as pointed out by the court at that time. There are numerous items that we know that were not included in the inventory. There is a concept introduced during the hearing that only items of a certain value, I believe the number that was used was something over $50, and that anything less than that need not be listed.
Mr. Curtin, you've obviously seen the BWC video.
Yes, Judge.
I think there were 3 or 4 officers that had video.
Correct.
So the way I read your brief, and if I'm wrong, please let me know and then we'll go from there. I didn't so much see that you were indicating that the officers, I think there were 2 who conducted the search, that they didn't do a thorough search of the vehicle. That is, it's not as though, like in some cases we have, where they just go to a specific spot where there's sort of a pretext inventory search.
Correct.
To me, it looked to me, you weren't contesting so much the breadth of the search, because the body worn camera video footage seems to reveal they looked everywhere and did a very undiscretionary search. But your point is they didn't do a proper catalog, so to speak, or inventory search form. I think they call it a tow report.
Yes, Judge.
So am I right on that argument? And if I'm not, go ahead.
No, Judge. Thank you for that question, because before I get to that, I also would like to point out that we're not challenging the Buffalo Police Department tow policy. That we challenge in no way. But to your question, Your Honor, we are not stating, there's no question that they did in our mind a thorough search of the car. So we're not disputing that. We're not saying that they focus on one part as opposed to in terms of ignoring any other part of the vehicle. What we're saying actually is that the body cam footage, if anything, shows that there are many items that they didn't list. So it's
Right.
sort of, they were thorough, but they weren't complete in terms of the inventory.
How thorough do the police need to be with respect to listing inventory? You saw in the video, there's an empty beer can.
Yes.
I assume you would concede they don't need to put that on the inventory list. There was some deodorant. Would you say that deodorant needs to be listed?
Judge, two things to that point. One is the inventory sheet actually above the signature says all items. Now I know that's being a little bit formal, but I would say the motivation for the inventory, in addition to protecting the state from claims of loss or wastage, or the agents of the state, the impound company, it should protect the owner of the car from the introduction later of items that were not present.
I guess your answer to the question would be it does have to list deodorant, but not the beer can.
How
about that coffee cup that was in the center console? Do they need to identify that?
I think they should, Judge. My hypothetical here would be you go to pick up your car that's been in impound, and there are items like that that weren't there when you left it, so to speak. And you have to question, what, was there a party in my car when it was in impound? I'm being a little bit facetious, I understand, but what I'm concerned about is that this idea of valuable items protects the state and its actors. I'm more concerned about things being introduced after my client no longer has possession of the vehicle.
But you would acknowledge in this case, and in a lot of cases, if they had to identify everything like deodorant and a coffee cup, styrofoam coffee cup, that they would be there for hours and the list would be pages and pages.
I believe that there wouldn't be, it wouldn't be, well, I'll say this, if there were so many items, hamburger wrappers, coffee cups, that it was overwhelming, then you could say large number of wrappers in the back seat, something like that. I think here we even have the police acknowledging that they didn't list things that they probably should have listed.
Yeah, Mr. Walker, or Mr. Curtin, the Walker case, did you come across that in your research from the Court of
Yes,
Appeals?
Judge.
And I looked at the briefs in that from the Court of Appeals. It's actually a case that came out of our court where we were affirmed. And looking at the briefs, and I couldn't get the record, but it says there the form completed by the trooper contained only 3 entries.
Right.
Miscellaneous items found in the trunk, paperwork, and the glove compartment, all of which was returned to, and the gun. So 3 entries only on the inventory report. And it was the city of Buffalo also. Miscellaneous items in the trunk, paperwork, and gun. This has more than that. So if we rely on Walker, you're kind of running uphill is my comment, but go ahead and fight back on that if you'd like.
Judge, I think, well, one question in Walker is, if we know that there are items, for instance, first of all, in Walker, I haven't seen the policy that was involved, so I don't know about the initial decision to impound. It seems to me the car was legally parked, so I have some questions there. But how do we know after the fact what's excluded from an inventory? That's it's sort of, to allow people not to list things defeats the entire purpose of an inventory in terms of protecting all parties' interests. So I understand, and I also understand that there are items that maybe I'm being a stickler on, but here we're not talking just about the beer can or the deodorant. We're talking about things, for instance, in between the seats, there was a compartment that was opened up, rummaged through, to use a phrase that occurs in cases.
The failure to
not
mention the knife or so-called machete, which is not listed, that's maybe one of the strongest points you'd have there. But we've got to look at Walker, we've got to look at our other cases about that you don't have to put every item down, et cetera. So
Understood, Judge, but even within the concept of not having put everything down, there has to be some sort of gradation. We can't assume that Buffalo police officers, and this is not a criticism, can value every item that they see. I think it's unfair to require that of them. And also that introduces such a degree of discretion in this case that I think it's unacceptable that they get to decide what is and what is not valuable.
Now, it's mitigated somewhat by the body cam video, just as Kern said. I mean, that's even better than a list. Everybody sees what was in that car. The failure, I know the policy says you have to list them, but there's really no danger here that anyone's going to be wondering if something was, what was in the car at the time with all this body cam video. But we're going to take a close look at that argument. Is there anything else you want to add?
Judge, to that point, it would be interesting to know whether or not the body cam footage is going to be available to individuals when they pick up their cars. Because that's, I mean, this will be. This is what will be on the car. And I don't think that they necessarily have access to the body cam footage. So that would be my only problem with using that as sort of a substitute or a supplement to the inventory itself.
We understand. All right. Thank you very much.
Thank you.
May it please the court, Jerry Mortier for the people. The question here is not, there's a difference between the why and the how as to why the officers did what they did. They abided by section 6.1 of the manual policy, which states that they can tow a vehicle when it's necessary to safeguard it and its contents from damage or theft. Here, it's an uninsured vehicle that we know it's not drivable and it has to be towed. So the question becomes how? And what the defendant is saying is that the officers should have made more of an effort to arrange an immediate private towing arrangements. But that's not what the Court of Appeals.
I think what his argument is that under the policy, there should have been some inquiry from the police to the defendant is, are you able to arrange for private towing? The problem for him is that's unpreserved. The motion below was based on you shouldn't have impounded the vehicle based on suspended registration. This is a new argument for the first time in an appeal, but that's what the new argument is you should have at least given an opportunity. Hey, can you get some arrangements? Can you call somebody? Can you get it out of here? If not, we're going to have to take it. I think that's the argument there. Could you address his contention regarding the listing of items? The motion court here had an interesting theory of why it was a lawful search. I haven't seen this before, not to say that it's wrong, but Judge Bowler seemed to indicate he had a lot of criticism of the police. Said it was a bad search, lazy, incomplete. He seemed to suggest, however, because the gun was found as one of the first items found, that there should be no suppression. He then adds later, if it was found later in the search, perhaps it'd be a different result. Do you agree with that rationale of when the contraband is found during the course of the search determines whether the search is lawful?
The lower court was making a distinction between a search, and this goes to one of the cases where a detective or an officer goes straight into the car, zeroes in on one area of the car, removes the contraband, and does nothing else. It's sort of similar to Gallic case where there was lack of written procedure or failure to record the property. What the court is saying is this wasn't a ruse to try to rummage through the car and go straight for certain evidence. The fact that they took their time, they took almost 8 minutes. We're talking at 3:15 in the morning, mid-January in February, which is pretty cold. And they took their time going through the entire vehicle. So what they're saying is they're not going to do that under those circumstances as to make sure that the court understands it's not a ruse. And I think that's what the court was getting at. There's this difference between zeroing in on certain contraband and doing a complete inventory search, which was done here.
Would you agree that if there's no inventory list, or if the inventory list is woefully insufficient, it's irrelevant when the contraband is found during the course of the inventory search?
Yes, as to no inventory search, and it depends on the extent to whether the inventory list is meaningful. In Bertine, they talked about a slipshod inventory. In Gallic, they didn't have an inventory list. So there's a distinction there.
Anything further?
No, Your Honor, I'll rest on my submissions.
Thank you very much.
Thank you.
We'll now call case 825, People versus Jimmy Wright. Counsel for the appellant is remote.
I'll rest on my submissions.
Thank you very much.
Thank you.
Mr. Schifrin, good morning. 25, People versus Jimmy Wright.
Good morning, Your Honors.
Counsel for the appellant is remote. We have, I'm sorry, we have a little bit of a delay.
There's about a 10-second echo during the prior argument. The argument was heard twice. I just alert the court to that. I'll continue, but just so the court is aware.
I'm sure we're working on it behind the scenes.
Thank you.
Thank you.
In point one, Mr. Wright.
Good morning.
Good morning, Your Honors. In point one, Mr. Wright is urging that it was a reversible error for the court below to refuse to instruct the jury on manslaughter in the second degree.
Mr. Schifrin, we are hearing that delay again.
Mr. Wright of the charge of murder and only include.
Counsel, can we are still hearing that delay. Tell you what we'll do. If you could hold on We're gonna call a couple cases where the lawyers are here. Maybe we can get that straightened out. I'm not sure if it's you alone or if it's,
People versus Holloway, this court held the manslaughter in the second degree, including intentional conduct
yeah.
under gross disregard of the risk of death,
Mr. Schiffer,
could reasonably find.
timeout. I'm gonna call timeout for a second.
I am too.
Yeah. I'm not sure what the problem is, but
I
we can,
apologize. It's very difficult. And
yeah, I don't know if it's on your end or if it's on our.
I'm not sure. I'll sign out again and sign back in, but I did that, just so your honor's aware, I did that twice during the first argument and the delay was there.
All right. It may well be on our end. If you could sit tight, we're going to recall the case momentarily. We'll call a couple other cases where we have lawyers here in the courtroom, and then we'll see if it's straightened out. All right, we will recall case number 825. Thank you. I don't know if it's on your end or if it's on our.
I'm not sure. I'll sign out again and sign back in, but I did that, just so your honor's aware, I did that twice during the first argument and the delay was there.
All right. It may well be on our end. If you could sit tight, we're going to recall. We will jump down to case number 832, Scott Miller Beauty Salon Incorporated versus Hamilton Stern Construction LLC. Case 832 is being called out of order. Good morning, Mr. Hooks.
May it please the court, good morning. My name is Robert Hooks from the Woods Oviatt office. Respectfully, your honors, an owner cannot simply ignore a warranty that guarantees a contractor the right to correct their work, skip past go, and just sue us for damages. The contract is clear that the owner had to give us notice within a year, shall give us notice, shall give us the right to correct the work, and if the contractor fails to correct the work within a reasonable period of time, then, and only then, can the owner seek to correct the work themselves.
So Counselor, your position is that provision, the corrective work provision, is almost like an exclusive provision.
Well,
Because-
it's a limited remedy. It is required that the notice be
So
given.
I understand how that works, but how do we then read, not necessarily the following section, but the 12.225 that says the owner retains other remedies?
Well, if we break down the language of 12.2.5, it says that any other obligations, and those are the operative words, any other obligations that the contractor owes the owner are not subject to this 1-year correction period. That's all it says. In fact, it concludes by saying the right to correct the work is still governed by the 1-year warranty. So the court below felt that those two provisions needed to somehow be harmonized, but the two provisions are not in conflict. One provision says you have 1 year and you have to give the contractor the right to correct. The other provision says there are other obligations in the contract. Those other obligations of the contractor are not subject to the right to correct. So we negotiate and we bargain for certainty in our contracts. And this state is proud of the fact that it's the center of commercial activity and it's the center of contract interpretation. A cardinal rule of contract construction is that you do not render words superfluous, meaningless. By trying to say that 12.25 is an option that an owner can resort to, renders superfluous the terms of section 12.2.1.
So when would 12.2.5 come into play?
Well,
What are these
there,
other obligations?
we specified in our brief, there are a number of other obligations a contractor has. The right to complete the work on time. I'm sorry, the obligation to complete the work on time, the obligation to provide insurance, the obligation to provide records, the obligation to meet the contract price. Those are other obligations under the contract for which the door is open to sue beyond 1 year. But that is not inconsistent with a right to correct the work,
Well,
requiring that we have that opportunity.
I'm not saying necessarily wrong, and I understand your argument, but 12.2.2.1 doesn't set forth any statute of limitations. It doesn't say you can't sue beyond the 1 year. It says during the 1 year period of correction of work, if the owner fails to notify the contractor and give the contractor an opportunity to make the correction, the owner waives the rights to require correction,
Right.
waives the rights to say, hey, come back and you used the wrong material here, or there's a problem here. The other side may say, we don't want a correction, we want to sue you. And is there a difference between requiring correction and commencing a lawsuit?
There is a difference, Your Honor. Within that 1 year, they have to give us a notice and we have to correct the work. If we don't correct the work within those 12 months, they can wait 3 years.
What if a contractor does a really shoddy job and the other side said, look, I don't even want you back on my property, you mess this up so badly. I'm just going to sue you. I'm going to hire somebody else. That's not permitted under this?
No, because that's not what the owner bargained for. The owner bargained that they will give us the opportunity to correct. The owner has the right, if we don't do a good job, to hire
Counselor, the way
somebody else.
you're interpreting that agreement that it only necessarily favors the contractor, it's the owner's remedy. Because it's part of the owner's remedy. The owner has a right to require work to be redone before substantial completion, which is not an issue in this case, or after substantial completion, which is at play at this case. That's the owner's remedy. And your position is, as I understand it, that's a condition precedent to suing on the contract for damages that you've got to give the contractor the opportunity to come in and make repairs. That's your position.
That is my position, but it's not one way. Because the owner has the right, if the contractor fails to correct the work, the owner hasn't been damaged, the owner has the right to now pursue a claim. So it's not a one-way street, it's a two-way street. The contractor has bargained for the right to correct the work. The owner reserves the right in the contract to still sue the contractor if the correction is still a failure. So it's a mutual binding provision. And again, 12.2.5 simply addresses periods of limitation with respect to other obligations. In other words, you don't have to give a notice within 1 year if you aren't meeting the contract price. Or you don't have to give notice within a year if you're not meeting. I mean, there's probably a dozen obligations, at least under an AIA contract, that bind an owner. And 12.25 is just saying, you don't have to give them a notice within a year to do that. Now, the second problem is that separate and apart from this legal interpretation of two clauses that are sitting there in harmony, the second problem in the case is that we put in proof, which is our burden on a motion, to show that we did the work, it passed code, it passed town inspection, it met code. Our contractor says the work was done in accordance with the specifications. The general contractor says the work was done in accordance with the specifications. That now moves the burden to the plaintiff to say there are real problems with this work. And all the plaintiff is saying is that the work wasn't done to first-class standards. we don't know what wasn't done to first-class
Mr.
standards.
Hooks, and you can correct me if I'm wrong, because you know the record better than I do, but your motion here, there's three theories here in the complaint that what your client did wrong here, one of which is didn't connect the existing sanitary line with the new line, the
Correct.
French line, and there was a lip there, and it wasn't flush. And because of the lip, object got caught up and it caused problems. That's one theory. Your argument here with respect to 12.2.2.1 is directed specifically at that theory, saying you didn't give us a chance to correct the alleged lip issue, right?
There was a meeting.
Right. I didn't see any argument being made that in the alternative, we've established as a matter of law that there was no lip, or we did the work in a proper fashion. You were just relying on that provision of the contract.
The testimony was that we ran a camera, everyone ran a camera down a dark, dirty pipe. There's images. Is there a faulty connection there? We don't know. So the general contractor talks to us. We said, fine, let's set up a meeting with the owner. There's only one way you can find out if there's a lip there, and you have to dig up the floor and you have to say, here it is, because that lip is under the concrete floor.
Right. So did your client establish as a matter of law? Let's assume it's preserved. Did your client establish as a matter of law that there was no defect, there was no lip?
We'll never know.
Right,
Because we were denied that opportunity. It's a catch-22.
right.
So,
They have the burden at trial, but you have the burden on the motion for summary judgment.
right, and we have the burden of showing that it passed code. There's speculation, what's this lip? There was testimony, it's a gray spot. You're looking at a black and white pictures from a camera in a dark, dirty pipe. Nobody knew what they were looking at. So we said to the owner, hey, if it's our problem, we'll dig it up. The owner says, no. I'm not doing that for business considerations. I got a business to run. But then he sues us 3 years later saying, hey, I'm suing you for damages because that unknown issue with the pipe is maybe worthy of a lawsuit. So the burden at some point has to be put on the plaintiff to say, other than you didn't build it to first-class standards. One of the primary arguments that we're running up against a hill with is that, well, you should have replaced the existing pipe, although we were under no obligation to replace it. And again, if they put in an affidavit from a professional construction expert that says, this pipe should have been replaced, anyone worth their salt would have replaced it. They don't do
If
that.
they didn't pay for a replacement, it would have been a lot more money. Your client wasn't obligated to replace it. It's really the lip issue.
Well,
What-
yes, and as we sit here today, we'll never know unless someone opens up that floor, is there a lip issue? Is there a
It
lip?
sounds like it might be a difficult case for plaintiff to prove at trial, if that's the case.
But as a legal matter, they have to give us the opportunity to inspect. As a factual matter, they have to do more than say, there's some dark spots in a picture. We think there's a lip problem. They don't even hire an expert to say that. They put it in through their plaintiff's attorney, who just says it wasn't built to first-class standards. That's like us shadow boxing in the dark. We don't know what that means if they're not going to articulate.
We understand your client, you don't believe your client should have to defend this through discovery and go all the way to trial when they have no evidence that there's a lip. And we'll understand that.
The final issue, Your Honors, is that we agreed in our subcontract, we agreed to indemnify the prime contract. We're the indemnitor. The general contractor is the indemnity. There's no question we agreed to indemnify for work covered under the scope of the prime contract. But the plaintiff is alleging more than that. The plaintiff is alleging that there was an unsigned addendum to that prime contract between the general contractor and the plaintiff. The general contractor testified, we never showed this unsigned addendum to my plumbing subcontractor. You cannot ask us to indemnify an amendment that was never shown to us. Is it enforceable? That'll be an issue at trial. But that's not our battle. We don't have a dog in the fight. So because the plaintiff is seeking indemnification, the plaintiff is seeking to assert there was a failure to inspect that existing pipe, which all that obligation can only arise from this unsigned addendum. And because we weren't privy to it, we weren't a party to it, we have no right to indemnify the general contractor for an unsigned addendum that was never shown to us. I mean, the general contractor does not deny that. He said, I didn't show it to any of my subs because I didn't consider it part of the plumbing contract. So for all these reasons, Your Honor, I respectfully ask that the decision of the court below be reversed. We be granted a dismissal of the complaint as to any plumbing issues, as to a claim for indemnification.
Thank you, Mr. Hooks. Good morning, Counselor.
Good morning, Your Honors, and may it please the court. My name is Maria Mastriano, and I represent Hamilton Stern in this appeal, and I won't take too much of the court's time. There's just a few points that I wanted to highlight from my briefing. Today, I'll start with the points with which I agree with ES Systems. First, Hamilton Stern agrees that the Scott Miller Salon failed to raise any issue of material fact in the lower court regarding the quality of the plumbing work. As counsel for ES Systems stated,
They didn't move for summary judgment, did they? You say they didn't raise an issue of fact. Don't we need to first determine whether the moving party has met their burden?
right. Well, I believe that they didn't meet the burden based on past code and so forth in the testimony. So then they needed to come up with a material fact. As counsel for ES Systems stated, the lower court appears to have presumed that the work was deficient with no admissible evidence from plaintiff or explanation from the lower court. And it appears to then have focused on the contract provisions as was discussed.
Well, just on that point, though, this was a motion by the third party defendant, and I believe the first exhibit was the Potter heating and cooling letter, which described, at least from their perspective, the problem right at the connection. There was a ledge, and that's in the moving papers. And that's what everyone is focused in on here. That's how it was introduced into the motion, was through that letter, and then in addition to the testimony of the parties that it's somewhat inconclusive. There is a problem here. The toilets are backing up. They're not supposed to back up. No one. So why are they backing up is the issue.
Well, first of all, I don't think that there's proof that they're backing up more now than they were before. And I'm sorry, I missed Judge Del Conte, I missed your first part of your question.
But you were alluding to the fact that your position as a plaintiff hasn't raised a question of fact.
Right.
And they would have to raise a question of fact, at least on this record, if the defendant had asserted that the work was done to the contract specifications. And what I mentioned is that in making the motion, ES submitted the plaintiff's expert's letter where he says there's a problem at the connection.
But then plaintiff said that was inadmissible hearsay and shouldn't be counted on in that briefing. So I don't see, if it's inadmissible hearsay, I don't understand how that's evidence here. Secondly, if I may move on. All right. Secondly, Hamilton Stern agrees with ES Systems that the lower court erred in its contract interpretation for the reasons that was explained thoroughly by Mr. Hooks. What I really was here to focus on is the indemnification provisions. While I agree with ES Systems on those points and the fact that plaintiff's lawsuit is groundless, pursuant to the subcontract with ES Systems in Hamilton Stern, ES Systems still owes indemnification to Hamilton Stern. The subject contract provides Hamilton Stern with indemnification against any claim, this is on the plumbing claims, any claim, even if such claim or any lawsuit arises, therefore is groundless, false, or fraudulent. ES System, there's no question, performed all of the plumbing work. And if the court deems that there is an issue with the quality of the plumbing work, ES System owes indemnification to Hamilton Stern. As Mr. Hook said, and as it was in his briefing, there's no dispute that under the terms of the contract, it agreed to indemnify Hamilton Stern for any claims arising from the performance of the contract. What ES System is saying is, well, but look, plaintiff's claim is really about the unsigned addendum and to replace the existing line. But as Justice Lindley said, there's other claims there as well that they're making, including that lip that you discussed. So there's other things besides that unsigned addendum, and therefore ES Systems would owe Hamilton System indemnification. Moreover,
You're not seeking indemnification here. I mean, you didn't move for an order of indemnification. You're not appealing on that issue.
no, but
Right.
I'm not appealing
You're
the
not
issue, but
seeking-
he
that's not-
appealed, but ES Systems appealed denial of the summary judgment motion.
Right.
And I had motion papers in the lower court.
You're
for
playing
indemnification.
defense here on that issue.
I'm sorry?
You're playing defense on that issue here?
Yes.
That's okay.
Yes, I'm sorry. The other thing I wanted to mention in terms of contractual indemnification is an indemnification issue is not moot, even if this courts grant ES System summary judgments, because there's still defense costs that were racked up by Hamilton Stern. In terms of, I'm going to move on to common law indemnification. ES Systems did not oppose that it owed ES Systems common law indemnification. And in terms of the insurances, and this is the last point that I'll make, in the briefing, ES Systems mentioned some of the insurances and said, listen, workers' comp isn't involved here and so forth. But they did not oppose that the general liability insurance is implicated here and therefore has conceded the point. And they didn't provide any evidence that any insurance had ever been procured. And unless you have any additional questions, I'll rest on my briefs.
Thank you, Counsel.
May it please the court, Lori Vahey from Vahey Law Offices on behalf of the appellant, Scott Miller Beauty Salon, Inc. As I won't repeat anything that has been already stated, although not conceding that certainly that the appellant has met their burden of proof. And that was really the primary basis for our opposition here. And we believe the court below got it right. Pardon me. With respect to, I'll start first because I think it's one of the easiest issues, and that is the contract provision of 12.2.2.1 and 12.2.2.5. I think the specific language in there, the court below absolutely got it correct. It's a specific performance provision. It does not prohibit a claim for damages. It actually ensures that the owner, who is my client, can go forth and sue for damages. I will note one thing, because I think there's some possible confusion, but I think the court got it right. The owner did provide, so we have a contract with Hamilton Stern, as you know, the general contractor. We did provide notice to the general contractor within the 1-year time frame provided for under Section 12. Then, as I read the record, and I believe it's conceded here, Hamilton Stern then provided that notice to the plumber within that 1-year time frame. So no one's
Isn't the issue with the opportunity to correct the defect, the alleged defect that's they're talking about?
You're absolutely right, Your Honor. It's the correction of the work. It's not exclusive to the remedies that my client has, and it can sue for damages. Interestingly enough, in New York State, we haven't found, at least I could not find, a provision or a case specifically on point with regards to Section 12, and that it's merely correction of work. It's entitled after substantial completion. So it seems certainly if it's a warranty period to come back, make it do it. Make it come back and fix it. That makes sense, but it doesn't get rid of any. I'm sorry.
This is a standard form contract
Yes.
in many, many contracts of this nature. And I looked the same thing, like surely this issue has come up before. Perhaps the argument has never been made. Maybe it's a novel argument. It doesn't mean it's necessarily wrong, but your research didn't indicate any decisions on whether this is a statute of limitations provision or not.
That is correct, Your Honor. I have not been able to find, certainly it says within here for the correction of work by its plain language. I could not find a case, but its plain language says that the time frame is for the correction of the work. And the reason that 12.2.2.5, I'll call it 5. The reason that 5 is so important is because it acknowledges this is just for the correction of the work that this applies. It does not prohibit the owner from bringing a claim for damages. There was notice here, ES Systems nor Hamilton Stern corrected the work. I mean, that's notable. They didn't do it.
Counselor, I'm going to just interrupt you because something that Justice presiding and what Justice Del Conte asked before kind of prompted this question. I'm hoping it's not totally off base, but having done enough of this work in private practice to be dangerous, so that's the best I've got. The AIA contracts are very sophisticated. They're developed with a long history of the knowledge of law and construction matters. So let's just and they're typically, to my knowledge, designed around what the common law is. So they're finding gaps in the common law and filling them, or otherwise changing from what the common law remedy would be. That's my general understanding as to some of the purpose of the AIA contracts. With that in mind, let's assume there's no contract. This is a long question. Assume there's no contract. Once there's substantial completion, that's a very significant date, correct? Because at that point, the contractor is entitled to payment in full.
That is correct.
Okay. So
If an architect, signs off and the contract terms are
and
completed.
here, Hamilton was paid in full by your client.
It was ultimately paid in full.
So under that theory, substantial completion has been achieved.
Yes.
Okay. So beyond that, the remedy, as I understand it, generally speaking, without a contract under law would be one of two things, the cost of repair or the diminution in value.
Yes.
Right. I litigated for years, the diminution in
You
value.
can tell, Your Honor, your cross me really well.
There was damage to a footer in a department store. What's that worth? Putting that aside. So for the cost of repairs, does this 1-year provision for the opportunity to repair, does that impact essentially how that will play a trial vis-a-vis what's recoverable? So in a sense, it's not necessarily where the plaintiff gets to sue for a breach of the contract and then, relies on that 1 year and it has to make that as a condition of proceeding. It's also potentially a basis for a defense or offset. That is, if you do not give us this opportunity, our cost of repairs may be nothing or maybe less. So what I'm driving at here, ultimately asking these questions, is this provision, which I agree with the justice providing, I don't see anything really interpreting it for us, but because we don't really know exactly on this record what it means, have they carried their burden?
Have they carried their burden on the issue of summary judgment for preclusion of plaintiff to seek monetary damages?
The
No.
limit you, because you didn't do this, you didn't let us repair, you're out of luck, you're done. You don't get cost of repairs, and you don't get diminution in value. Because theoretically, you could seek diminution in value at trial. I'm not sure if that would be worth going to trial, but that's for another day. So really in this record, have they carried their burden to establish as a matter of law that you are precluded from any further recovery under any theory?
No, Your Honor. We think that with respect, there's a couple things there, if I may. If I'm hearing Your Honor correctly, you are saying, is this a preclusion, provision if you don't satisfy what's in there, and that's that notice and allowing us to correct? And assuming that that's how the provision should be read and not a specific performance provision, they've failed. And the reason that they failed, Justice Kern, is because we did provide notice. We did give them an opportunity. They did not want to do it unless we could, if they dug everything up, they wanted to dig up the whole business and they wanted to say, not our problem. And so they would not pay for it. They did not agree to correct the work.
Well, they said they wouldn't pay for it if it wasn't their fault.
That's correct. And they said that
They were willing to
beforehand.
pay for it if they get under there and they say, yeah, it was our mistake. But in any event,
And that does not just include, were they going to pay just for the pipe? Now you've dug up the floor. I mean, they had other opportunities. They could have done other things, but the biggest thing is they didn't satisfy its burden on this record to suggest that somehow that the plaintiff failed. I mean, that's what they needed to do. We've shown notice. We've shown we gave them the opportunity. The issues with regards to code, I would respectfully submit, you can't just testify to it. Where are the records? There are no records that have passed code. There were 3 things on this motion in terms from plaintiff's perspective, what they're saying was wrong. And this was filed prior to expert discovery. I'll just, disclosures, I'll mention that. And with regards to this letter that was relied upon, we did claim that it was inadmissible hearsay because it's a fact witness who did not testify, but plaintiff can rely on that in opposing this motion here. And with regards to the failures, it's not only the lip, certainly the lip, because we have Hamilton Stern saying to its plumber, got a problem with the fern coat, got this lip. It's the bellies in the line, and it's also the issue of the bends and putting that together, regardless of whether it's to code, with the other problems. And that's what's discussed in that letter. And expert disclosures are going to be provided in this case. They're going to provide additional information. And certainly what happened here with ES Systems is it did not put its own expert affidavit up. It did not have an expert to explain why the provision, it satisfied its burden to correct the work, or it didn't have to correct the work. And it gave its affidavit only of Jerry McEvely from ES Systems, who said, I don't know. I don't know. It's inconclusive. We don't know. And so somehow to suggest that plaintiff had a burden on this motion for summary judgment when it's Hamilton Stern that has brought the claim against ES Systems. And it's talking about, it has 6 causes of action: contribution, indemnification, common law, contractual, and failure to cure. Apparently, failure to cure is admitted. They did not get the insurance, but really here we're focusing on the indemnification. And that's what brings us to these issues, of course, of negligence and whether the contract was satisfied. And we think with regards to Section 12, and particularly as Justin Kern asked with regards to, we think it's a specific performance provision. We don't think it's an exclusion of damages provision. If it was, it would so state. And so for us to infer that into this clear language, particularly when Section 5 says that's not the case, it does not get rid of the owner's other damages or rights to other damages, we would respectfully submit, Your Honor, that the court below held properly. It should be affirmed in full. And I thank you for your time unless there's any other questions.
Thank you, Mr. Fink.
Thank you.
We're going to try 825 again. We have reason to believe the delay problem has been fixed. You know, Mr. Schifrin, if you are out there, please reconnect. Good morning again.
And I apologize. Apparently the problem was on my end, and I apologize for that very much. Thank you for allowing me to argue later. In point 1, Mr. Wright is urging that the court below committed reversible error by refusing to charge as a lesser included offense manslaughter in the 2nd degree, in this case in which the jury acquitted of the charge of murder and convicted only of the lesser charge of manslaughter in the 1st degree. In People v. Holloway, this court held that manslaughter in the 2nd degree includes intentional conduct undertaken in gross disregard of the risk of death, and that a jury could reasonably find that a defendant acted recklessly in causing death by striking a single blow to the victim's head with a wooden bed slat. Citing Holloway, the 2nd Department in Asaro held that where a defendant in a barroom brawl with a number of people hit the victim with a baseball bat with a single blow, that constituted manslaughter in the 2nd degree. The 1st Department in People v. Claudio held it was reversible error for the court in a murder case to not charge manslaughter in the 2nd degree, where, in the words of the 2nd Department, the defendant, quote, viciously clubbed, close quote, the victim with a single strike of a baseball bat to the victim's head.
Mr. Schifrin, can I ask you this? Is it your theory on the charge now that there's a reasonable view of the evidence that your client, Mr. Wright, recklessly struck the victim in the head with a bat, that he did not intend to hit him in the head with the bat, and that's where the recklessness came in? Or was the recklessness, did it come in with respect to the injury? In other words, he intended to hit him in the head, but he did not intend to cause serious physical injury. The jury already determined he didn't intend to kill. Is the reckless with the injury or with the swinging of the bat?
As in Holloway, Asaro, and Claudio, There was recklessness as to whether he was intending to cause either death or serious physical injury because he wasn't focused on that. This was a melee with 20 to 30 people participating. There's a video in the testimony of one person. He's jogging up, does a single blow and leaves. That's not intent. You can't find under the light most favorable to the defendant, which is of course how we have to consider this in charging a lesser. You can't find there's no reasonable view that the man with the bat was acting recklessly with death, but intended only serious physical injury, but not physical injury. We don't
Right,
know,
so just-
and that's a jury question.
Would you agree that these kind of determinations are very fact specific?
And that's why a jury should be deciding that fact-specific determination. Exactly, Your Honor. It's not fact-specific that, gee, he hit him hard and he died. He hit him hard and he died in Holloway. He hit him hard, a single blow, in Sarro, and he died, and in Claudio. In all those cases, a jury determined, the first two, the jury determined that it was manslaughter in the second degree. In the third case, Claudio, it was reversible error to not allow the jury to do so. In this case, in People versus McIntosh, which Justice Presiding Lindley and Justice Kern were in the panel, held that it was reversible. There was error to not charge manslaughter in the second degree when there were two stabs, one that went 4 inches deep into the person's chest, where the defendant testified that he intended to poke. So that goes back to Justice.
Okay, Mr. Schifrin, so I the cases that you cited, and I looked at all of them. There was, a melee going on, to use your words. In this case, isn't it true that the incident between the victim and your defendant happened away from the melee? I would say that the victim had already withdrawn from the melee and was no harm to anybody else when he was then attacked by this defendant away from the melee. And so we have to consider that, all the circumstances, and compare them to the cases that you cited.
First of all, we don't concede it was my client. The person with the bat, after an incident where there's a melee going on, that's the context in which the person is running up, or in the word testimony wasn't running, jogging up, does a single strike and leaves. The question of whether it was intent to cause serious physical injury, any intent other than I'm mad and I'm swinging a bat, that's a jury question. That's a classic jury question. To say no, a jury couldn't reasonably find it here, they could find it in all those other cases, is for this court and the court below to take away the jury function. The jury should have had the opportunity to determine whether he acted with a less culpable mental state, and that was denied. The case is cited.
Just so I can clarify, so we put this part to bed, you are conceding that there's no reasonable view of the evidence that your client did not intentionally strike, that the person with the bat, say it, did not intentionally strike the victim in the head. That was an intentional act, striking with the bat, right? You
Yes.
agree with that?
Right.
So it's just, is it reasonable that when whoever swung that bat to such a degree that he killed the victim intended less than serious injury and maybe just physical injury, bumps and bruises? Is that reasonable?
Holloway, single intentional swinging of the bat. That was the court found in Holloway there was intentional conduct and it was reckless as to death. This court found manslaughter in second degree.
How about Rios? Your opponent, Mr. Schifrin, your opponent relies on Rios, which then cites Asaro, which is your case.
Right.
What is your interpretation of Rios?
As I pointed out in the reply brief, the Rios was an issue as to whether the single swing of the bat was reckless manslaughter or depraved. No one contended, and the court did not find it was intentional homicide. As this court is well aware, the depraved murder is not intentional. So Rios did not in any way answer the question or stand for the proposition that the respondent asserts his response to that somehow it was disavowing the holding in Asaro. Rios never considered whether this was intent and should have been man one or intentional murder. Only issue whether it was so depraved it wasn't not merely reckless but depraved. I couldn't find a case like this where there's a single swing and the determination was it had to be a man one or a murder, it could not be man two to such a degree. We're not permitting the jury to decide that. This jury rejected the theory that the hit was hard enough that it had to be intent to cause death. We don't know, going back to Justice Bannister's question, what the jury would have done if they had the opportunity to decide the right mental state. That's why, again, I was mentioning McIntosh before. In McIntosh, the error was harmless because the jury in McIntosh convicted of murder not of man one, and therefore the majority of the court, and I know Justice Lindley and Justice Curran, you're on that panel, determined that you couldn't reach the issue of whether it was reversible error not to charge man two. Here we have the verdict for man one. The harm here is clear. The jury had a choice, either not guilty or guilty of man one. They knew it wasn't murder, and we didn't have that fair trial for the jury to decide this. This was a classic jury question. The circumstances, yes, there was, aside from the main part of the melee, but in the context of this fight going on for a while, people were heated. Who knows what the intent was? I don't think anyone could assume.
Can we look at the post-striking conduct of the person with the bat to determine intent here? There was, based on the video, which I know you've watched many times, there appeared to be some taunting and some mocking, perhaps. And then he attacked the woman's van and smashing that. Is that irrelevant to determine what his intent was moments earlier when he killed this man by hitting him in the back of the head with I think it was an aluminum baseball bat?
Yeah, I can't say it's irrelevant. I can say the amount of relevance is a jury question. Clearly this is whoever that person was heated up and upset. Okay, did that mean he intended to cause death? That he intended to cause serious physical injury, or that he was reckless as to what it means when he does those things? That is why we have jury trials, Your Honor. The cases again cited by the people versus Aveals. But page 11, they cite two cases, People versus Aveals and People versus Oliveri. In neither case did the court consider man two. In Aveals, the Court of Appeals held it was reversible error to not charge man one as a lesser in a homicide case and never reached the issue of man two. And in Oliveri, the only issue is whether it was proper to charge man one. So respectfully, those cases don't help the people. But I could see why, listening to the panel, there's questions like, gee, maybe this guy really did intend to cause serious physical injury, but maybe he didn't. In the light most favorable to the defendant, this person who wielded that bat was heated up, wasn't thinking consciously, I'm going to try to cause serious physical injury. He was trying to strike something. Striking something that is reckless as to the substantial possibility of death. And that's why
I think the DA is going to get up and argue that you intend the natural consequences of your acts, and when you swing that hard and hit a person in the back of the head with an aluminum baseball bat, it's not reasonable to assume that you intend to cause mere physical injury, which is a very low stand, bumps and bruises and things of those nature, injuries of that nature.
They argue that in summation as to why it had to be murder, and that was rejected. The jury didn't see it the way this panel appears to be seeing. This was a heated person who wasn't consciously thinking of anything. He was doing what the classic definition of recklessness was. He was consciously disregarding the very substantial risk that you swing a baseball bat, an aluminum baseball bat, bad things could happen. This wasn't someone who had a planned attack and I'm trying to cause injury. And calculating what that was is why, again, in Claudio, that was held to be reversible error not to charge it, and why in Claudio, not only was held to be reversible error not to charge it, the Court of Appeal, the First Department in Claudio said he viciously clubbed the person with a bat, and still it was reversible error not to charge man two. Why? Because the person might not have considered the consequences of his behavior, and that therefore man two is appropriate. It might be that if this panel, your honors were on the panel, you might say, gee, looks pretty intentional to me, but that's not the standard. The standard in the light most favorable, could the jury have found that this person did not consider the consequences of his acts, but rather acted out of anger, haste in the process, swinging away, whether at a person or a car, without realizing or thinking through what was going to happen. And that's why we have jury trials, Your Honor. The
Correct.
issue of identity was the primary issue at trial. And the primary strategy with respect to the issue of identity was to attack the reliability of the identification testimony of these two women. Despite that, the counsel didn't make a motion under People versus Reeves, which was decided more than a year prior to this case, to move to suppress as unreliable. That was controlling law. It remains controlling law because neither this court nor the Court of Appeals has held otherwise. This was a perfect case to make that motion. Both women took more than 5 minutes before they made an ID, and the science is clear, as the courts pointed out in Henderson and Lawson, that after 30 seconds, what you have is not identification or recognition memory, but what you have is comparative judgment. Which person in the array looks most like the person who I observed committing the crime, and that's why it's unreliable. And the proof of that is Ms. Pinero not only took more than 5 minutes, but she initially picked out someone who could not have been the defendant because.
Right, Mr. Schifrin, and we read your brief on the Reeves issue, ineffective, and as you know, I dissented alone in Reeves. It was 8 years ago. It has not been cited once anywhere. I keep waiting for defense lawyers to be making the argument, and finally you are, but it's been ignored vigorously by judges, trial lawyers on the defense side, prosecution. It seems to be perhaps a one-off in that case.
Respectfully, Your Honor, the failure of trial counsel to make Reeves motions speaks more of problems with the bar than whether it's still controlling law. And obviously, Your Honor wrote a very lengthy dissent and granted leave in that case. The bottom line is, it was at the time of this trial, and as I speak today, still controlling law in this department. And the failure to take advantage of that is, I would argue, inexplicable. This was a case not only took more than 5 minutes, the photo arrays were more than a month after the incident. Again, factors that impact the jury, the reliability of identification. The jury was never instructed at all on either how the delay in making an ID or the delay in the procedure could impact reliability. And not only, and the reason this is a problem is this court's aware of this research. It's been before the courts numerous times. The jury wasn't aware. So he didn't not only make a Reeves motion, he didn't bring an expert to make sure the jury was aware of that. And the
So if you're right on that issue, it would be remitted unless you went on one of the prior issues. If you went on ineffective assistance of counsel, it would be remitted for a Reeves hearing to determine the reliability, which sounds a little like trial. The jurors are assessing the reliability of their identification.
Well, respectfully, the same way with Huntley hearings, you get 2 bites at reliability. Under Reeves, you get 2 bites at reliability because the danger of ID evidence is there's very compelling. That's the person I saw commit the crime. That's why misidentification is the leading cause of wrongful convictions. So to prevent that, we want to keep unreliable evidence out. Reeves, especially Your Honor, Justice Lindsay, you're aware of, relied on language in Manson versus Braithwaite of how reliability is a linchpin of the admissibility of identification evidence. This case, I mentioned 2 of the factors: the 5-minute delay and the month delay. 5 minute delay making the identification at the array, which was a month after the incident. Very short-term time to observe the person under very stressful circumstances and cross-racial ID. This is, as attorneys have been doing this for quite a while, I can't think of a case where Reeves would be more applicable. So we would look forward to a Reeves hearing. And if we somehow lost that Reeves hearing, which I hope we wouldn't, we would call an expert, because that's what you do to make sure the jury is aware of those factors when they're being called upon to weigh the reliability of identification evidence. They're not given the tools to do so when they're not presented with that information, which again, I'm aware of, you're aware of, but the jury wasn't aware of.
Thank you for your argument. Thank you.
May I please the court, counsel, Christina Harper for the people. I will start with point 1. Your Honors, there was no reasonable view of the evidence to support a finding that the defendant acted recklessly and not intentionally. And that's what is required in order for the defendant to get that instruction. The facts of the case are very clear. There was a blow with the bat that was inflicted upon a victim on to the back of his
It
head.
wasn't a glancing blow, was it? It wasn't just a glancing blow?
Correct. It was so vicious and hard that the victim actually fell onto the ground. So to say that this was merely reckless it simply does not fit the facts of the case. In my brief, I did cite cases on page 13 that talk about situations where a conduct would be reckless, and there have to be some facts supporting the recklessness.
How about the fact that this was a melee?
That is not dispositive of recklessness.
Right, but we're supposed to look at it, aren't we, in the light most favorable to the defendant here?
Yes, Your Honor.
If there's a possibility.
This possibility has to be respectfully, this possibility has to be there has to be some evidence, there have to be some facts to substantiate that possibility. As the Court of Appeals stated that
it sounds like what you're suggesting here is that that the trial court should evaluate the facts there right then and make that determination. But the question is like, isn't that supposed to be done in the light most favorable to the defendant, so that if there's any question, and that's the issue here, is there any possibility during this melee that it wasn't intended to be a blow to the head that would cause serious injury? The defendant's entitled to have the jury make that determination.
Yes, the defendant is entitled for the jury to make that determination, but there have to be facts in order to support that. It cannot be.
Got hit in the shoulder or the back, different case?
Perhaps would be different.
Right. So we're assuming that the victim was involved in trying to separate people at the time, right? There were girls who were fighting and he was reaching down, he was involved in that near the fence area. Isn't it possible that the assailant, who you believe is the defendant and the jury believed is the defendant, swung and tried to hit him, not necessarily in the back of the skull, but to free the person that he was grappling with?
Then there should have been evidence to support that proposition. In cases that I cited on page 13 of my brief, in all of these cases where the instruction was given by the court, there was some evidence, whether there was a testimony that someone was swinging the bat with his eyes closed, not even looking where he was swinging, and that's the case, People versus Claudio.
With respect to did he intend to hit the man? We're talking about recklessness with respect to cause injury here.
Right. It seems to me that the facts that support the mens rea here, we have to infer why did he swing the bat? Did he swing the bat for one purpose or another purpose? And based on the melee, if the victim had moved or dodged or weaved or whatever, is there some possibility, and even remote possibility, in the light most favorable defendant, could he have not intended that strike to be?
Respectfully, I would submit that under the facts of this case, there's no possibility.
Yeah.
Given the fact.
Maybe you can correct me if I'm wrong. The melee is going on, and the actual victim here had removed himself from the melee and was walking away from the melee when this defendant came upon him and from behind and swung at him, not to protect himself, not to protect anybody else, but swung at this victim.
This is absolutely correct. And also to corroborate that, there was some evidence that he was apparently after inflicting that very significant blow to a victim, he was actually mocking his actions. Furthermore, he followed the victim into the van and smashed the windows of the van.
I guess your argument is if he didn't intend to cause serious physical injury and just a mere physical injury, his behavior was not indicative of that. You would think if you see somebody collapse like that, you would be like, oh my goodness, let's call an ambulance. Sorry, I didn't mean for that. His behavior is totally contrary to such an intent, would be your argument.
Correct.
He seemed to celebrate it and
Correct.
continue on with aggressive behavior towards others.
Correct, yeah. And that's the facts of this case are very clear that this conduct could only be intentional and not reckless. As to defendant's reliance on Holloway, I just would like to note that the Court of Appeals made it very clear that the same action cannot be both intentional and reckless. And I would cite People versus Gallagher that was decided around the same time as Holloway. Holloway is not cited. There are only a couple cases where it was cited. In fact, this court in People versus Robinson that was decided 2 years after Holloway declined to follow that rationale, clearly stating that the same act cannot be both intentional and reckless. Moving on to point 3 that was brought up by defense counsel, ineffective assistance. In my brief, I did explain that the defense counsel here was not ineffective for not requesting a hearing that clearly he was not entitled to.
Not entitled to a Reeves hearing? Why not?
Because, Your Honor, the case law is very clear that the reliability of identification is decided by whether or not the identification was suggestive.
That was the position I took in Reeves, and nobody agreed with me, not a single human on the panel. So that's not the law. The majority in Reeves says you can get a suppression hearing, you can suppress evidence based on concerns about reliability, not suggestiveness alone.
This kind of rationale, and Your Honor, I did read the briefs in that case, and the case Reeves talks about actually photo array identification where photo array was not introduced at the hearing. The literature that discusses Reeves talks about the fact that if the people failed to provide the photo array for the court's review at the Wade hearing, there is a rebuttable presumption of unreliability. So this was in Reeves, the defense never actually requested the hearing that defense counsel is arguing, the reliability hearing. The issue in Reeves was regarding that photo array that was never presented to the
Yeah,
court.
I don't think it was a photo array. I think it was a long photo.
Photograph, Your Honor, yes.
Yeah. All right. Well, we'll take that under advisement.
And that's why I believe this is distinguishable. And even even if this court were to decide that that the Reeves hearing should have been requested, this hearing would not have been successful for the reasons that I stated in my brief. The research regarding the identification is really not conclusive, despite of what the defense counsel states. And in support of his argument, he cites 2 out of state cases. But what he does fail to acknowledge is that in both cases, the courts actually concluded that the research was inconclusive to make this the time within which the witness conducted the identification as one of the important criteria in determining the reliability. Unless.
Yeah, I think your brief covers the remainder. So thank you very much.
Thank you.
We will call case number 829, matter of Osiris K. 829, we have 2 submits, and I believe the attorney for the child is remote. We'll give her an opportunity to be heard briefly if she wishes to be heard. Counselor, you may unmute yourself. Your opponents have submitted. Your colleagues, I should say, not all opponents. Is there anything you want to add that's not in your brief this morning?
Good morning, Your Honors, and may it please the court, Roxana Herod on behalf of the child, Osiris K. I'm just here to say that we would ask the court to support the finding of family court. We would rest on our papers, but are available to answer any questions the court may have about how our client is doing.
Your client is still in the foster family that been with,
Yes.
and it's pre-adoption. Everything's waiting on us. Is that accurate?
Yes, that is.
And that's a suitable home in your view?
Absolutely. My client is very bonded and is thriving in his current home.
All right. Thank you very much.
Thank you.
Case number 830 is matter of Sarah Blair versus New York State Office of CFS. Mr. Burke is with us. Opposing counsel is virtual. And we'll give counsel an opportunity, Mr. Burke first, to log in here. And counsel is with us now. So Mr. Burke, you may proceed. Thank you.
Morning. Thank you, Judge Lindley, and thank
Let me
you.
just say before you begin, we're very aware of the facts presented in this case. So if you could maybe address it with some the court.
Of course, Your Honor. Put plainly, and good morning, and it is an honor to be before Your Honors. My name is Kevin Burke. I'm from the firm Gross Schumann, and I'm here on behalf of the petitioner and the appellant. Put plainly, we are here because the court, the administrative law judge who was not present at the hearing, misplaced the burden of proof on my client, the petitioner Sarah, I'll refer to her, and misapplied the 10 factors used pursuant to the guidelines that Your Honors have already read and understand. I'll be as simple as I can without getting into any of the facts. Fundamentally, there was a misunderstanding about my client's acceptance of responsibility in this case. She pled nolo contendere. She did not claim that there was no abuse. She did not pretend that she was not a participant in that abuse. She did not deny culpability. Quite to the contrary, she accepted it and she did not challenge it. The issue here is, was there sufficient proof that that abuse was reasonably related and relevant to my client's ability to be a teacher in the future going forward? And I know you've read
Service Law 422(8), I believe. Before we go further on that, your client was a teacher employed at a charter school.
Correct.
And the concern here is that this indicated report, if it's on the central registry, is going to affect her employment there and elsewhere. Is she still employed at the charter school?
She is.
So the school, I assume, because this is on the registry now, the school's aware of the situation and they are not taking action to terminate her based on this indicated report?
I do not know, and it is not in the record, whether the school is aware of the situation. I do know that should our client apply for a job, certainly in the public school setting, this would absolutely come up.
Right. So this is going to affect her moving laterally or up to another school. It may not affect her current employment status.
That is
fair
correct.
to say? All right.
That is
You
correct.
may continue.
And effectively what happened not in the hearing, but as the ALJ, who apparently reviewed the transcript of the hearing sometime later, determined, is effectively what happened here is, because of the nature of the abuse and because of the, shall we say, shocking or distasteful nature of that abuse, the burden of proof ultimately got shifted on the second point as to whether that abuse is relevant
to her ability to teach going forward. And the only evidence submitted during the hearing suggested strongly that my client had successfully undergone extensive counseling, extensive training, and even the attorney for the child put in proof suggesting that everyone was aware of what happened. Everyone was aware of the circumstances surrounding what led to that happening. Everyone was aware of my client's involvement, whether either actively or passively in that involvement, and that the report from Catherine Meyer Davis, the attorney for the child, indicated that there was extensive professional review of all of the facts, and that my client had rehabilitated herself, had effectively repaired her relationship, not only with her daughter, but with her grandmother, that they were all successfully thriving, and that it was highly unlikely, if not impossible, that this situation could happen again. Now, Administrative Law Judge Downey turned that on its head. She seemed to suggest that the fact that the attorney for the child advocated on behalf of my client was further indication of abuse, and nothing could be further for the truth. There was no evidence in the record to suggest that my client encouraged or asked her to do that. And in fact, the only evidence in the record suggested that it was the child herself that had advocated that this not be an indicated report. And in fact, the evidence in the record demonstrates that the child herself testified in the underlying family court action on behalf of her mother and against her stepfather. None of this is to suggest that what happened was okay. None of this is to suggest that my client's role in any of this, or lack of role is probably the better way to put it, is in any way excused. We're simply talking about a going forward prospective basis. And the fact that the attorney for the child put evidence in the record in support of my client and advocated that this not be an indicated report, not only was that not considered, it was considered improperly. It was used against our client.
I'm sympathetic to the argument that as a teacher, there's very little danger to her students in the school setting that something like this would happen. This happened in the home in a very private manner. I would think it is very unlikely that she poses a risk of something like that to her school students. What the county, the state would be arguing is the registry isn't just for employment, it's for adoption, it's for foster care. And if the report isn't indicated, your client would be eligible to become a foster parent and have another child come into the home, could adopt another child. Isn't that a legitimate concern here?
Well, under matter of Hastings, which all the parties have cited in their papers, that would fall into the category, respectfully, Your Honor, of just pure speculation. And there is nothing in the record to suggest that my client is interested in doing that. No one has suggested that she's tried to do it and can't do it. And that's not an issue that was before the court below. I absolutely understand why you're asking that question. And I understand philosophically with that, with the, the thinking there, but that's just not in the record.
That's not her mind. That's not in her playbook. She has no intent of doing that, but it would, if she were to change her mind, there's nothing in the state registry that would preclude her from doing so, I guess is their point. Highly unlikely though it may be.
Well, I will follow you down this hypothetical path, Your Honor, and suggest that even if that was something that was put before the court, which it was not, but even if it was, the reports from Catherine Meyer Davis, from the Child and Family Services report, the other evidence that was submitted in affidavit form, all suggested that our client has been 100% rehabilitated. She's been trained to recognize boundaries.
Counsel, if I may, as I understand the determination here was that your client's judgment was so profoundly poor that she can't really, that it impacts her responsibilities as an educator, because she might not, for instance, be able to report to the child abuse hotline if she was aware of something else that she found, she got some information in the classroom. That she couldn't perform those other duties that an educator is responsible for given the demonstrated lack of judgment in this particular case. That was the linkage.
I agree with you, Judge. And that was the error because that looks backwards. That looks at the state of my client before the indicated report, and certainly before my client actually reported this abuse. When my client, and the evidence showed, once my client, the second my client learned of what had happened, she is the one that reported this to the sheriff's department and got the district attorneys involved. She was the one that was involved. And in fact, the record shows that she applied for a protective order against JB. Well, he's an adult, Jonathan Blair. And she asked for an order of protection, keeping Jonathan Blair away from the daughter and from her.
This was after the disclosure, though.
Well, contemporaneously with the disclosure. The disclosure was made all on the same night.
Right. My understanding is, correct me if I'm wrong, but the mother was aware of the request that her husband had made with respect to the child and gave her consent to that. And that then the abuse took place for 18 months thereafter.
Well, that's actually a fact. And you're right, Judge, reading the record, you reading the decision, you would think that. Reading the record, you would not.
How long was it between, okay, you can go ahead and do that under certain conditions with my daughter, and the disclosure of the abuse?
There is no evidence in the record as to the timing of any of that. In fact, ALJ Downey concluded that the one led to the other, and that is just not in the record. That it is not clear, and to this day, my client is not sure when that happened, if one preceded the other. There were two forms of abuse. The one that you're talking about, certainly my client had a role in and never disputed and never, but you'll notice in ALJ Downey's decision, there's no discussion really of the other abuse.
Right. Well, you're making a lot of good argument, and you're advocating extremely well for your client, but would you give us this much? Just this much, is that your client's decision to say, yes, go ahead to the request. You're not going to get into the details there, but that was an absurdly
yes,
horrific parental judgment on a scale that I'm not sure we've seen in this courtroom in many years.
I agree with you. And that's why she pled nolo contendere. And that's why she has never disputed that. She has never challenged that. She has never tried to introduce evidence of an exculpatory nature regarding that. She's accepted that. And that is one of the things that has been used against her, or that was used against her by ALJ Downey. This idea that she somehow tried to excuse it. She never did. She never put up any fight on that whatsoever. And that's why it's an irrebuttable presumption of abuse or maltreatment. She's, and the lower court's right, not the lower court, the ALJ Downey was correct on that. But she makes much of the fact that that was somehow established. It was conceded. There's no question. I don't want to make it sound to Judge Del Conte like I'm skirting his question, though. The answer to whether my client Sarah is in a position to be a mandatory reporter or somebody who could, the evidence in the record overwhelmingly shows that she has been rehabilitated on that point. She understands that she has to, if there is a situation where boundaries have been crossed or there's been any kind of inappropriate behavior towards a child, that not only can she not go along with it, she's got to report that. And the only evidence in the record on that point favors my client, the petitioner. Basically, because these facts are so horrific on the first point, we believe the evidence about the abuse was so bad, and we never disputed that it colored the analysis of whether or not it was rational or reasonably related to the future.
It's one of the factors that the ALJ was able to consider, the heinousness of the initial act.
Yes. Regarding that decision, though, as she went through those factors, I would say, on the 6th, 7th, and 8th factor, she took evidence that should have been favorable to our client and turned it around and made it unfavorable to us, involving the ALJ, not accepting responsibility. These are all things that we believe are contrary to the weight of the evidence. And frankly, that's why I'm here before you, because we're challenging how the evidence was considered.
Right. Mr. Berkeley, thank you for your argument.
Thank you.
I'll turn it over to Ms. Raimondi.
Your Honor, Rachel Raimondi for respondent. This is a substantial evidence case. The question before this court is whether the ALJ's R&R determination is reasonably or plausibly derived from the record. Counsel's taking issue with how the facts of this case were interpreted by the ALJ, but it's the ALJ's duty to interpret the facts and, as the Court of Appeals stated, apply the guidelines to the facts in a common sense manner.
What do
And
you
that's-
say about Mr. Burke's argument that the ALJ shifted the burden of proof, had the wrong burden of proof here?
Well, that's just not true. What he's arguing is
So who has the burden of proof here on the reasonably related to employment issue?
so the agency has the burden to show that it's reasonably related to employment, adoption, and foster care, but it's petitioner's burden to show that she's been rehabilitated. She has to provide the rehabilitative evidence. And that makes sense because there would be no way for OCFS to provide that sort of evidence. That portion alone is on petitioner to demonstrate. And here, the ALJ considered petitioner's rehabilitative evidence, but just found that it wasn't persuasive. And that's a reasonable determination where rehabilitative evidence is but one of 10 factors. And one of those other factors is that seriousness, when you have facts such as these, should be considered twice. It gets extra emphasis. That's factor or guideline, really, number 10 for this analysis. Now, counsel is really narrowing the scope as to the teacher role and the teacher's duties. The question before the ALJ was whether the maltreatment, looking backward and then forward only as to rehabilitative evidence, is reasonably related to employment generally in the childcare context, adoption, and foster. And for this, the ALJ found that the maltreatment is related because petitioner showed such a profound lack of judgment. We're not saying that she is likely to repeat this maltreatment at school as a teacher. We're saying that because she showed such a prolonged, profound lack of judgment, that's related to her participation in the childcare field. I'll note that this is not disclosed as a matter of law after 8 years. There's nothing in the record to indicate that she is under a threat of losing her job right now. And when a agency who is allowed to get this information from the registry requests it, the only thing that's indicated is that petitioner is on the registry and indicated for inadequate guardianship. It's then petitioner's responsibility to talk about the facts, and she can explain all of her rehabilitative evidence to the prospective employer. This is
It's not a bar to future employment. It's not a bar to her current employment. It's something that the employer should be aware of in your view and can make a determination after hearing from the petitioner whether this is someone they want working with children.
That's exactly right. It has nothing to do with her license or her ability to teach. All it does is lets, in this case, school districts, for example, know that they may want to ask her about, has she been indicated? And can she explain, how has she rehabilitated herself? We are not necessarily disclosing the facts of this case, just that she has been indicated for inadequate guardianship. Counsel made a lot about this letter from the child's attorney. The letter is not dispositive. Again, this is a common sense application of 10 factors to the facts of this case. And unless the court has just on the argument that the court found that she did not accept responsibility. That's not the case. The court acknowledged that she accepts responsibility. The ALJ. The ALJ just doubted that she was sufficiently rehabilitated, that she sufficiently understood that what she did was so egregious. her testimony made a lot of pointing to, well, I consented to the request, but I didn't think it would turn into what it turned into. She did a lot of talking about how she thought that this was the best thing that she could do, how she weighed her choices and she thought she came to the best result. But she didn't take sufficient responsibility, or she didn't show that she was rehabilitated enough to understand that what she consented to was egregious.
All right, thank you, Counselor. Thank you for your argument.
Thank you.
831 is De Palma versus Western New York Urology Association. The appellant has submitted. And we have Mr. Gruber's here. We have, of course, read your thorough brief. You are entitled to argue if you wish, or if you want to turn it over to the panel to see if anyone has any questions or concerns about your brief.
I will be brief and then turn it over, Your Honor.
All right, thank you.
May it please the court. Good morning, Mark Gruber on behalf of the defendants. This is a unanimous jury verdict in favor of the defendants. Clearly, the jury found that the evidence on behalf of the defendant was more reasonable and more credible, and so found. None of the appellant's issues either are preserved on this appeal or find any support in the record. We've always felt that this is a frivolous case. The appellants did not prove their claim, which is an impossibility that a circumcision could shorten the penis. Thank you.
Thank you very much. Case number 833, Mary Garner versus Benchmark Abbott Road Plaza. It's case 833.
Morning, Your Honors. Justin Hendricks of Kenny Shelton Lip Technoec on behalf of the appellant KDJB Foods. This is a pretty straightforward argument. We think that the documentary evidence that was submitted in support of summary judgment was not authenticated and thus couldn't be used by the movement to meet their burden, and that the remaining proof, which would comprise of the deposition testimony, was not sufficient to meet their burden, and that the lower court got that wrong.
If we were
Certainly happy to entertain questions.
If we were to assume without deciding that you're right, that on authentication, that the lease was not authenticated, the invoices and the repair records, none of it was properly authenticated. So that's inadmissible. We have deposition testimony of the store manager and various other individuals, plaintiff. The focus is on did the moving party meet their initial burden of proof with that testimony? If you want to address that, I think you would agree that the testimony establishes that the plaintiff slipped on substance, water perhaps, inside the store. I think you would agree that the testimony establishes that. I think you would agree that the testimony of both representatives from KDJB Foods and also Benchmark established that the landlord was out of possession, was not responsible for any in-store defects. They were responsible for the exterior. I think you would agree that the exception to that would be if there were a leak in the roof, which is their responsibility, and then a substance water came in, rainwater, what have you. That's the only situation where they'd be responsible. Would you agree with me that the deposition testimony established all of that?
I think that's a good encapsulation of the facts. And we think that from that starting point, there's sufficient evidence on both sides that would necessitate a fact finder to make that determination rather than the court.
So it would have to be, for the motion to be denied, the evidence submitted by the moving party would have to raise an issue of fact, because your client didn't submit any evidence in opposition, right? You relied on Mr. Schul's memorandum of law and his affidavit. So it rises or falls on, did the moving party meet their initial burden? Do you agree with that?
Well, yes.
Yeah. So in the moving party, they had plaintiff who testified she slipped in the dairy section. She saw water on the floor. It looked like it might be coming from underneath a freezer there in the section. and undisputed that she slipped on something inside the store.
Yeah, Your Honor, it's really just, did the water come
Right.
from that freezer? Did it come from the roof?
Or it could have been somebody just spilled water.
Yes, admittedly, I don't think there was any evidence submitted on that point
Right.
to be,
Correct.
I wish it were, you know?
The only way your client could be held liable, I'm sorry, the only way that the landlord would be held liable is if the water came from the roof and there was a leak.
Yeah, from the evidence before the court, yes.
So where in the deposition testimony does it establish that there's testimony about leaks in a closet, there's testimony about leaks at one end of Aisle 8. Where is there an issue of fact with respect to whether that water came from the water upon which plaintiff slipped came from a roof leak?
It would be from the deposition testimony of Mr. Conley and his testimony regarding that there was a leaking roof roughly the same time as the plaintiff's accident. Again, we've already established that Benchmark was responsible for the roof. The leaks occurred more than once, and that when leaks occurred, they were not necessarily adequately addressed on the first attempt, and Benchmark would have to send out a second team to do additional extensive, greater repairs.
You're probably referring to Mr. Conley's testimony, page 252, 257, around there in his deposition, where he says, although there was a roof leak above Aisle 8, at some point, the leak was toward the front of the store, not in the area where plaintiff fell. There was some also general testimony about roof leaks in general, other roof leaks, I guess, are close in time to the fall. So that's enough in your view to raise an issue of fact. We can get it to the jury.
Yes, Your Honor. The classic view taken most favorable to the non-movement, that Mr. Connolly's testimony is sufficient to create a question of fact as to where did this water come from the roof, such that Benchmark would still be in the case.
And your point is that the landlord had the duty to prove as a matter of law that it did not come from the roof.
I would argue, yes, Your Honor, that as the movement, they bear the burden of removing all of those questions before you even have to look at my papers.
I'm trying to pin you down on the leak from the roof. That could be the only other source for which the landlord was liable, as I understood your earlier answers to the Justice Presiding's questions. Is that right?
Yes, only the roof is the only argument before the court as a source of water that would be Benchmark's problem. Yes, there's no other source that we are arguing for this water that would be the responsibility of Benchmark.
And your client, you would agree, did not in opposition submit any evidence that the leak came from the roof. So you're just relying on, you don't get to our burden because they didn't meet theirs.
Yes, I mean, the argument is, again, solely from Mr. Connolly's testimony. There is no additional evidence that we submitted.
Understand. All right, anything further?
No, Your Honors. Thank you.
Thank you.
May it please the court, Jennifer Rogers on behalf of the respondent Benchmark. I believe the Justice Presiding has essentially outlined our argument that even without the lease, without the work orders or the documentary evidence that was provided, the testimony from all three parties, including the plaintiff, is pretty straightforward. She's testified.
Just before we get started, are you running up the white flag on authentication, whether the evidence was?
Admittedly, yes, Your Honor, this is not my finest hour. I'm not going to lie. But yes, I think that there are some issues there indeed with the lease and the work order.
We can throw all those pages of the record out and we'll just focus on the deposition testimony.
That would be fair. And I think that is precisely what happened in the court below.
In your motion papers, and this is sort of a source of confusion for me, and I'm still sorting it out. That is in subparagraph 2 of your motion papers. You say that Benchmark was an out of possession landlord with no duty to repair or maintain the freezer/cooler that leaked water onto the floor. The supposition therein is that the leak necessarily came from the freezer/cooler. Did you meet your burden vis-a-vis the issue about the leak from the roof? Does the deposition testimony, again, irrespective of the documentary evidence, does the deposition testimony show as a matter of law that the leak that caused this fall, allegedly, did not come from the roof?
I believe it does, Your Honor.
How so?
The plaintiff testified unequivocally that she was in the dairy section. She slipped and fell and was shown a photograph, which is part of the record, of the area in which she slipped, which was at the end of this long cooler that runs the length of the aisle. She indicated that that was the area in which she saw the water or the substance that she slipped on. The testimony from Mr. Connolly also, when looking at that same photograph of the area in which the plaintiff fell, testifies that he recalled a roof leak, but at the opposite end of the store, which would have been toward the front of the store. When confronted or when questioned about when these roof leaks occurred, he couldn't say with any definitiveness that they occurred at or around the time that this particular incident occurred. Mr. Nosavage, who is the vice president of facilities and works in the property management, testified that he could not recall any work orders for any type of roof repair in March of 2021, which is when the plaintiff slipped and fell. The testimony is also unequivocal from Mr. Connolly that he was responsible for those coolers that run the length of the dairy aisle where the plaintiff fell. And Mr. Nosavage testified that the landlord, Benchmark, is not responsible for any of the interior plumbing or anything like that. This is all the main maintenance issues of the tenant itself. And they had been a tenant since 2005. So this was an ongoing tenancy. This is not something that, you know, they just moved in and there were all kinds of problems and nobody said anything, or there were always recurring issues. The testimony specifically indicates that the leak was not near where the plaintiff fell. Plaintiff herself testified she did not see any evidence of anyone working or any type of construction or any type of other repair work going on when she was there. It wasn't raining outside. She essentially eliminated other issues as to where this, or the source of where this substance came from, other than showing the photograph and indicating that she slipped on the floor.
Would you agree that the testimony that the water extended to under the freezer doesn't establish as a matter of law that the water came from the freezer? It may have started on the floor and migrated to under the freezer. It doesn't necessarily mean it came from the other direction. It doesn't conclusively establish the water came from the freezer. You need more than just a plaintiff's testimony. I saw the water under the cooler.
I would say, Your Honor, that considering the fact that there was no testimony that there was a roof leak that was repaired anytime before this occurred, and that the tenant himself or the owner of the store himself could not testify that there was any type of roof leak in that same time frame, and that it had occurred at a different spot in the store, I would say leads to the conclusion that it wasn't just plaintiff's testimony that the water came from the cooler, but there is a presumption that it must have come from the cooler, as there is no evidence of any other roof leak other than the suggestion by counsel.
Right. And it doesn't necessarily have to come from the freezer for your client to prevail. It's undisputed that this dangerous condition was on the interior of the store. The landlord has no obligation for the interior. That may be enough in your view to shift the burden to them to say, yes, it was interior, but it came from something exterior. Any other explanation but the roof is not on your client.
Absolutely, Your Honor.
All right. Thank you very much.
Thank you.
Case 834 is Eternal Beverages Incorporated versus Mayer Brothers Apple Products Incorporated. Case 834.
Good morning,
Good morning.
Your Honors, barely. May it please the court. I'm John Horn, Harder Seacrest and Emery, on behalf of defendant appellant Mayer Brothers Apple Products, Inc. Just to set the stage, Eternal Beverages sells bottled water, and for about a decade, between
Mr. Ward, the
2012.
relationship started, I'm sure the panel knows the facts very well. The relationship started in about 2012, and in about 2019, there was discussion about doing bottling of a different type and size of bottle. 2020, it kind of didn't work out. Somewhere maybe late 2020, I think it was notice of a price increase around fall. For about a year thereafter, through about December of 2021. Purchase orders were issued, invoices were issued and were paid by the plaintiff at the increased prices. And then for about 15 invoices thereafter, they were not paid, with the unpaid amount to be about $1 million.
That was perfectly
I just want you to know that I can assure you, the panelists make a real effort to be familiar with the facts, and that they've got that.
Generally, your claim, because time is running here, it's undisputed that the plaintiff paid for no invoices that were sent. There were no objections to any of these from December 17th of 2021 to August 21st of 2022. Over $1 million worth of bottles were sent. No objections, no payment. You're basing with the assumption that their purchase orders were acceptance of a contract from that email of November 18th, 2020. That's a breach of contract. And you win on that. Now, whether they have a contract against you, a breach of contract for the 2.5 liter bottle is a whole nother matter. But there, in your view, there's no way around the fact that they owe you for those unpaid invoices.
That's exactly right, Judge. That either the combination of those purchase orders and invoices combine, right, to constitute an enforceable agreement, or if the court were to determine that that isn't sufficient to constitute an enforceable agreement, then there is no question but that they received $1 million worth of water and were thereby unjustly enriched by that.
Right. Now,
So
damages might be a different issue because they have some complaints about the quality of some of those bottles. You're not saying you're entitled to the full 1 million and change. That would have, you agree that would have to be litigated separately, how much they owe you for all those invoices?
no, Judge, we wouldn't. There isn't sufficient evidence and wasn't introduced in the court below as to any of those supposed defects. The issue was, is there a defense to the $1.2 million, either in the form of, hey, we had this agreement and you agreed to hold your prices in place, right? So that was that September 2019 email. That was the defense number one. And defense number two was, we signed this under duress. That duress, of course, was created years after the fact, was never voiced contemporaneously, and it's undercut by the ratification in the form of paying those invoices for the next year.
And would not explain at all why you pay nothing. Like if you were under duress, you were happy with the other prices before they got double or tripled, and you're under duress. Well, how do you owe nothing? You would at least owe that prior amount. But in any event,
yes, that is true, Judge.
They just decided to pay nothing until they had their own in-house operation up and running, and then they just started slipping. Your client is the way that you look at it. It seemed like the trial court here thought there was one contract, and because there's issues of fact one way, there's got to be issues of fact the other way. You look at there's two separate agreements here in your view. One with the bottles that they had previously provided for the 1 liter, 1.5 liter, and 600 milliliters, and then the second agreement with respect to the 2.5 liter bottles.
I'd say it a little bit differently, Judge. Our view is there is only one agreement in this case, and it's the one that's formed by the combination of the purchase orders and the invoices. That's the agreement, right? And that had been the deal from 2012 all the way up until the time it was no longer the deal because they decided.
Said alleged contracts, because they're alleging a contract with respect to 2.5.
Well, yes. So the second point, right, is that there was this 2.5 liter deal. And that is part of that September 2019 email exchange between representatives of the respective companies. But on that 2.5 liter deal, it's important to note that the first cause of action, which we sought summary judgment and dismissal of, alleges the existence of an oral contract. There's no evidence anywhere in the record, and that's on page 24 of the record, no evidence anywhere in the record of a supposed oral contract for this 2.5 liter. Rather, this 2.5 liter hourglass shaped bottle was the subject of a document dubbed a proposal, and we view it as a proposal, right? This email exchange in September of 2019, pursuant to which originally Mayer Brothers said, okay, conversations had gone on at length. We really don't want to be part of this 2.5 liter thing. We're not built, we're not set up to run this, but we will do it if you provide the following equipment, and we'll do it at $1.75 a case. The response to that was, we're not going to pay you any more than $1.25 a case. And in that context, we proposed, okay, let's give it a trial run. We'll try to do it at $1.25 a case. You give us the equipment to get us set up so that we can drive efficiency, ideally make a little bit of money on this thing, and we'll see how it goes. If it doesn't work, we'll come back.
They're going to try for 3 or 4 months of trial run.
And what happened then, Judge? 55,000 bottles, or excuse me, 55,000 cases were produced during that trial run between May and August of 2020 at a cost to Eternal of $1.25. In August of 2020, Mayer Brothers decided, again, consistent with its understanding of the trial nature of this running out of the 2.5 liter production. Mayer Brothers said, okay, we can't do this at $1.25 anymore. We're going to charge you $3.10 a case because we can actually cover our costs and make a little money at $3.10 a case. So for the last $6,780 cases of the 55,000 that were produced during that trial run, Mayer Brothers invoiced Eternal for that 6780 cases at $3.10 a case. What happened after that? In October of 2020, Eternal paid that invoice. No objection, no muss, no fuss, but that was the very last purchase order for the 2.5 liters. The parties.
So can I ask you a question? When you say no objection, was it just no objection in writing? Were there oral objections?
Judge, there isn't any evidence, not the deposition testimony or anything else, of oral objections on that 2.5 liter question in the summer of 2020. And in fact, there is no evidence of oral objections other than Mr. Mashouf's deposition testimony years later that they objected even to the increase in prices on those other bottles I'm sorry, I'm looking up at this screen. I don't know exactly where to look at you, Judge. In November of 2020. There is no record of any contemporaneous objection. It was all manufactured after the fact in order to get out from under the obligation to pay the $1 million. But on that 2.5 liters, it's important to note that the last invoice for $3.10 a case was issued after the final 2.5 liters were manufactured and shipped. It was paid by Eternal, and that was it. They never ordered any more. The parties could not agree on the price per case for that 2.5 liters. And so what Eternal did then was say, okay, we're not doing this with you anymore. We want our equipment back. It's undisputed that in December of 2020, Mayer Brothers sent them all their equipment back. And that was the end of the trial run saga. And by the way, that has nothing to do with the $1,002,304.19 we're seeking in this case.
On their claim, they're essentially seeking, as I call it, cover. That is, we had to go out and get cover for this product. So the Supreme Court kind of looked at that as a question of fact, and as the Justice presiding indicated, maybe then that bled over as being a uniform contract. I'm going to switch it back to your counterclaims just so I make sure I understand it. You've got 19 invoices, and 4 of them, there are 4 invoices that do not, maybe it's 5, that do not compare, do not have a matching purchase order. Right, according to your statement of account. Maybe it's 4 or 5, whatever, but there are certain invoices, whatever the number is, that are not accompanied by or preceded by a purchase order. Otherwise, I have 13 purchase orders that resulted in 14 invoices and trying to match them up in the record based on your statement of account. What I'm driving at is, if you succeed on your counterclaim for breach of contract, some of that might be also unjust enrichment for those invoices that do not match up to a purchase order. Am I close?
I don't think so, Judge, because there isn't any question. We've got deposition testimony from the COO of Eternal, and we walked through this in detail over the course of several hours during his deposition, where ultimately we got to that $1,002,304.19. And he agreed that that was billed and not paid.
Mostly focusing on the downtime delayed bottles issue. I think during the deposition testimony, they indicated they didn't agree to that. But I'll take a closer look at it, Mr. Horn, just to satisfy myself on that issue.
I don't think there is a question of fact on that, Judge. I think we got to a final number on that, but obviously you have looked more closely, more recently at that than I have.
Last question I have, and then your time is just about up here. There was this dispute about the PE labeler, this newer one, that the other party was supposed to get to the Mayer brothers to continue with line 32, the smaller bottles, right? In the September 11th, 2019 email, one of the commitments from Eternal was to provide this new PE label that would make it more efficient and less costly. They seem to say, and then in November of 2020, November 18th, your client raised the prices drastically. And one of the excuses was you didn't give us this labeler. Do we know when we know they got the label because they put it in their own facility. Do we know, there's some indication that they purchased it in November of 2019. Is that your understanding? In other words, because they seem to be saying in the brief, well, we didn't have it. It takes a long time and everything. It's not our fault. We were going to get it to you, but it takes a long time. We just didn't have a chance. Do the dates line up on that argument for that?
I don't think they do, Judge, but the way the argument, as I understand it, goes is that this is an agreement in September of 2019. You're going to hold your prices at the 2012 level. We recognize you haven't raised them in 7 years, but you're going to continue to hold them there. And we're going to help you drive efficiency, wring out cost by providing this first-rate PE labeler. So essentially you'll be able to run bottles through faster, you'll get them labeled faster, less people, so on and so forth. So we're going to provide that for you. And there were representations made throughout 2020. It's on the way. It's coming. What we do know is, because the deposition testimony is very clear on this, during that same time, they were ramping up to bring this whole operation in-house.
The principal testified they purchased the PE label in December of 2019. December of 2019, he testified he purchased it, which would mean he had it for a long time before they turned it over. Now, I don't know if purchase means obtained, but your client's point is that you never gave us what you said you were going to give us so we could raise our prices. We never agreed to keep those prices till the end of eternity anyways.
Well, that's entirely true, Judge, which I think renders that agreement argument defective as a matter of law, right? But they didn't provide the PE labeler. There is ample testimony on that. Not only did they not turn it over to us, not only did they admit 6 ways from Sunday they didn't turn it over to us, but they actually kept it for themselves, shipped it to their facility in California, and we confirmed as much. There's testimony that Mr. Mayer, as the CEO of Mayer Brothers, confirmed that that PE labeler was not coming to Mayer Brothers. And it was after that that they increased the prices again for the first time in, at that point, 8 years. So they bumped up the prices. And what happened right after that? We know that Eternal started issuing purchase orders. In other words, started buying water at those new prices. No objection. No, we're not paying this. No, it's extortionate. No, nothing. They paid everything, continued to issue those purchase orders well into 2022. It wasn't just end of 21, continued well into 2022. And the cases we cite on this question of duress are very, very clear. The Scheinlin case, among others. Once you adopt, embrace, ratify, act in accordance with some new deal, you can't be heard later on to say, oh, we were forced to do it. It wasn't in our best interest.
You owe nothing.
And it certainly doesn't mean you owe nothing.
I think we understand. We'll turn it over now.
Thank you.
Mr. O'Brien, a lot there to digest. Where do you want to start?
Thank you, Your Honor. May it please the court. Good afternoon at this point, first to say it. I think we should start with whether the email correspondence and the context around that in the record constitutes an enforceable agreement.
Or at
Because
least creates a question of fact that an issue vis-a-vis this appeal.
even better said than me, Your Honor. And because in Eternal's position, the trial court was dead right on that point. And assuming that is correct, it has a waterfall effect down all of the remaining issues that were just discussed in the opening argument. And just briefly, I know the court is very aware of the underlying facts, but there was testimony from Mr. Nowak from Mayer Brothers, the director of sales, that in and around 2019, Mayer Brothers had one other customer that had what he referred to as a dedicated line, meaning one line of production that was only used by that particular customer. Okay. And how do you get a dedicated line? You make certain investments, you give certain resources to Mayer Brothers, and in exchange, you get your own line. And most importantly, critically for this case, you get what I will call stagnant co-pack fees, fees which remain at an agreed upon level, not subject to change. And if you look at the email, specifically the opening email from Mr. Nowak.
What's the date on the email you're referring to?
I'm sorry, Your Honor.
Which email, are you referring to the September 11th, 2019 email?
That's correct, Your Honor. 870 in the record, the email from Mr. Nowak to Mr. Morcamo at Eternal.
Yep.
You know, the opening line in that email is Mayer Brothers would like to be Eternal's Northeast solution for all of its distribution needs. Right? This was a change in the scope of a business relationship that had gone on for a long time. And the email can't be taken just in the context of the four corners of that email. You can see it's actually a chain of multiple emails. And there's testimony in the record that in between the emails, there's phone conversations going on talking about the context of who is going to do what obligations are going to be subject to for both parties, and then the resulting final email, which is written acknowledgement of the 1.2 co-pack fee. I'd like to note quickly, it was addressed this concept of a 3 to 4 month training period or trial run. I disagree with the reading of this email agreement in that regard. I think it's a 3 to 4 month trial run at that price point. And if it does not meet that price point, it goes back to the previous price point in this agreement, which is materially different than what the price was ultimately changed to by Mayer Brothers about a year later. So assuming that the trial court got it right and that there's at least a question of fact as to whether this email constitutes a valid agreement.
A valid agreement with respect to the 2.5 liter bottles you're talking about now?
I'm talking about both, Your Honor.
Both of them, okay.
Yes, both. And so it's clear, I don't know that this can be read as two separate agreements. There are certainly separate obligations within both lines. But again, to point to Mayer Brothers' own language, we would like a long-term partnership and to be your East Coast solution. This is all one in the same in terms of the scope of the relationship. Eternal was looking very hard at this time for a third party to fill the 2.5 liter water bottle, and it was struggling to do so. And Mayer Brothers provided a potential solution as part of a global relationship. So assuming that there is a question of fact as to whether the email agreement is enforceable, then the concept of the subsequent price change, and more specifically, Eternal for a period of time paying those prices impacts whether one, those can constitute a separate enforceable agreement, and two, what obligations Eternal had to comply with that change after the fact.
Right. Would you agree with me that the price increases came in November of 2020?
Yeah.
Your client obviously upset with those drastically higher prices, but they continued to order them and pay for them for quite a while, almost a year, right? They continue to pay for those. In your view, that doesn't create a contract under the UCC? The provider is saying, well, I'll do it at this price. Your client orders at that price, they get delivered, invoice payment. That's not a contract?
That's correct. And there's two reasons for that. One is that that argument narrows the scope of time just to those specific purchase orders while ignoring the previously enforceable contract. Two, the purchase orders, although accepted, were if the email agreement is an enforceable contract or there's a question of fact, then the concept of the actual material breach being the price change being a term that Eternal assented to belies common sense. And I think the record after those price changes and the filled and paid for orders shows Eternal's intent in that regard, specifically that, and I disagree that there's no evidence in the record that they objected. Mr. Morcamo and Mr. Mashouf, the two heads of the company, testified at length to the actions they took to try and get Mayer Brothers to honor its previous agreement. I think that the testimony was begging. And, you know, the concept of the deposition testimony in the lawsuit being so far removed from the time that it's insufficient. Well, there's clear testimony that Mr. Mayer shut all communication with Eternal down after they changed the prices. Essentially said, I'm changing the prices by 4 to 5-fold, and I'm refusing to communicate. You pay and you deal with it.
Is it your argument that Mayer had no right under the September 2019 contract to increase the prices in that matter?
Absolutely.
And so those prices from September 2019 email, there was no time limitation on that. They were bound to provide the packaging fees at those prices forever?
Hypothetically, yes, Your Honor. I think there is a broader business context here, which is that the parties have worked together for a long time. And there's testimony that the co-pack fees hadn't been changed for a decade before. I don't think it's unreasonable to read from the agreement that there was not a time expiration.
Indefinite, just for, what about new PE, the obligation to provide a new PE label, or they say, even if you're reading the contract is right, well, we're not obligated at those prices because you never gave us what you said you were going to give us.
Understood, Your Honor. And I think the record is relatively clear that Eternal did everything that it could have to perform in that regard. So there's two labelers that are ultimately at issue. There's the temporary labeler that I would call the refurbished labeler. And then there is this new fancy PE labeler that was supposed to come and change the efficiency game for Mayer from
the email says new PE labeler.
Correct. And so there is testimony in the record that this PE labeler, stumbling a little bit, was expected to take between 12 and 18 months to get from purchase to the point where it could be delivered. This is not a piece of equipment you can get at Ace Hardware. It's a somewhat complex piece of equipment. And there's also evidence that Mayer Brothers was involved in what I would call the design of the PE labeler. There's email communication copying Ken Nowak on it with the labeler manufacturer saying, hey, this is the plan. It's going to Mayer Brothers. Are you okay with it? No objection.
Right. So your argument is your client didn't have time enough to fulfill that part of the contract, and it took too long. It took a long time to get the labeler, and that can't be deemed a breach. We understand that. Any last points you want to wrap up with?
I would just say, with regard to the unjust enrichment claims, the concept that even if everything that I'm saying on behalf of Eternal is true today, they certainly received product and they didn't pay for it. So there is a gap there. Eternal's position is much different than that, which is that if Mayer Brothers had honored the contractual prices in terms of the co-pack fees, and then you take those prices and you multiply it by the volume of bottles that were filled over the entirety of this time period, that Eternal has actually overpaid considerably for the goods that it had provided. And with that, I appreciate the time. Thank you.
Thank you. Case 835 is Daniel Lopez versus Millard Fillmore Suburban Hospital. Case 835. Counsel for Appellate is appearing remotely. Mr. Kassar is here. Good morning to you. Ms. Matry, you may proceed.
Good morning, Your Honors, or good afternoon. Excuse me. May it please the court. I know that this matter has been well briefed, but I just wanted to take a few moments to discuss a few critical points that I believe are necessary for the court to consider with respect to whether Dr. Adams and Delaware Surgical's motion for summary judgment was properly denied. It turns on two questions: whether the plaintiff's expert submission created a question of fact, and the second question being whether or not that question of fact was based on a new theory of liability raised for the first time in opposition to summary judgment. We contend that it absolutely was a new theory of liability, not because it's before surgery positioning or during surgery positioning or repositioning. It comes down to one word, Your Honors, and it's palpate. The judge's decision, Judge Sampson decided, and that's at page 13 of the record, that the question of fact created by plaintiff's expert submission was that Dr. Adams failed to palpate the leg after he
Does that mean, forgive my ignorance, but does palpate the leg in this context mean supposed to massage the leg to make sure the circulation is going? Is that what the alleged failure here was?
It's palpate in this context would be to place the hand on the back of the calf and press in to see if there's rebound pressure, essentially. But it's done after the patient is positioned. The issue here, Your Honor, is that the word palpate is never mentioned in this litigation. This case was commenced in 2018. Dr. Adams was deposed for over 4 hours in 2021. Bill of particulars we received, I believe, in 2019, and the motion wasn't until 2024 when the word palpate appears for the first time. Palpate, I respectfully submit, in reviewing your Guyette decision, a new theory of liability because it's not so reasonably inferred from positioning. The allegations, yes,
there's a theory, there's an allegation about failure to maintain circulation, blood circulation. Is that not palpating the calf? Isn't that what we're talking about here?
No, Your Honor. And in the bill of particulars there, and I can see that circulation did come up in Dr. Adams' deposition, and it was addressed. And how circulation would be monitored by anesthesia, by nursing, by everybody in the operating room. That is different than palpating, because the plaintiff's expert said you position the patient and then you palpate to see if there's pressure on the leg to determine if your positioning is good or if you need to reposition the leg. That is something completely different. It is not just monitoring the circulation. So the issue is Dr. Adams was asked extensively about how he positioned the patient, how the patient was put in the stirrups, what angle he was at, how it was in relation to the rest of the body. We got into all sorts of specific details. Not once was Dr. Adams asked whether he palpated the leg after he had initially positioned the patient. It's not a reasonable inference for any defense counsel, any physician, to infer that palpating the leg is somehow inherent in the allegation about positioning.
When you're palpating, or when they allege that your doctor should have been palpating, isn't that just another way of saying that you're assuring that there is no interference, with the blood flow to that extremity? I mean, do we have to get that specific about the language? Palpate, touch, make sure that there's a circulation. Like I'm finding it to be, a matter of semantics almost here.
Your Honor, respectfully, it's not just a matter of semantics, because palpation occurs in many medical procedures and many medical diagnoses that have nothing to do with compartment syndrome and have nothing to do with positioning of patients in surgery. It's a very, I'm sorry.
Let me ask you this, counsel. In the bill of particulars, they talked about that defendant failed to take precautions or actions to maintain circulation. And whatever they may be, observing, touching. Why aren't they all under that same umbrella of taking precautions?
Because, Your Honor, well, first of all, let me start by backing up just a little bit, because whether it be failure to make sure there's circulation, failure to make sure that there is pressure on the leg, not pressure on the leg, by palpating, by observing, by visualization, all of that. The fact is that the expert could not even say it. The plaintiff's expert never said that Dr. Adams didn't palpate the leg. He never said it. He said, this is what should be done generically. He never goes so far as to say that Dr. Adams didn't palpate the leg. And why? Because he can't, because it's not in the record. There's no allegation that Dr. Adams should have documented that he palpated the leg. There's no allegation, in other words, because it's not in the medical record that was before the trial court, that's of no consequence. That's not part of the allegation. He was never asked. It never came up. And if you look at the level of detail that Mr. Knopf took in deposing my client, he was never asked. The trial court then goes on to say, well, Dr. Adams could have put in an affidavit attesting that he did. Your Honor, that would have been improper, because our expert, who was very, very detailed in our moving papers, in the affidavit that he submitted in support of our motion, the one thing that he didn't address was palpation. And why? Because based on the evidence, the proof that was put before the court in support of the motion, didn't address palpation because it wasn't brought up. It wasn't addressed. It wasn't pled. And it is a very specific allegation. It's not just inherent and the very generic allegations. Plaintiff had every opportunity.
Ms. Matry, real quick, just focusing on what you just argued a second ago. Is it your position that in a medical malpractice case, the plaintiff must allege such specificity in the complaint that not only was there a failure of proper positioning, but the failure of proper positioning also wasn't, for example, failing to properly cushion with this type of cushion, failing to use this type of support, failing to have palpation, getting to your precise point. So are you saying that those specific types of details supporting the failure to position properly must be alleged in the complaint?
No, not at all, Your Honor. That's not what I'm asserting at all. And in fact, I don't even assert that it should have been put in a bill of particulars, so long as the defense has some reasonable inference or some reasonable basis to believe that this needs to be addressed. And that's typically, as this court has said in its recent decision, that you need to give the defendant some reasonable notice. And that's when you question their client. That's when you ask questions of other defendants that might be in the lawsuit. That's when you do your pleadings, when you do your bill of particulars. Plaintiff had every opportunity after they had this reviewed by an expert to make an application to amend, even after the note of issue. These motions weren't until 2020.
Your position is that your client could have put an affidavit or testified at deposition that he did palpating. He didn't because he didn't realize that was that issue. How about the, if you want to address briefly before your time is out, this issue of repositioning versus pre-positioning. And the bill of particulars seem to allege that the negligence was you didn't reposition during the surgery. And then now the expert says, well, we're abandoning that. We agree that the patient shouldn't have been moved once it started, but started out in the wrong position. Judge Sampson seemed to look at that as the repositioning took place when the patient was in the room. He didn't come in those stirrups. So he was repositioned from his natural state of sitting there into the stirrups, and that's enough for repositioning. And that was one of his analysis. You want to address that?
Yes. The way I read Judge Sampson's decision was, again, looking at plaintiff's expert submission, it's not so much that you reposition before the surgery starts. It's after. Okay, so you position the patient, you palpate to make sure that there's no pressure. And if there is pressure after you palpate, then you reposition before you even touch the patient with a scalpel, before you even touch the patient with a robot. That's the repositioning that I understood from in reading the judge's decision and also considering that what the plaintiff's expert actually had to say about what he meant by repositioning. That's just if you position them, you check for the pressure. If the pressure's there, you reposition them until there's no pressure. That's how I understood it, Your Honor.
Anything further?
Your Honor, I would just note that the footnote by the court in its decision, again on page 13 of the record, that Dr. Adams could have addressed this through a submission and summary judgment, Your Honor. If certainly Dr. Adams would have done that if he had been aware that palpating was considered part of the positioning. Again, you know, the court goes on to say that he could have put it in a submission. Had he done that in reply for the first time, certainly then it is impermissible under the CPLR, but it also would be considered a credibility issue, and it would be a question of fact no matter what.
Thank you, Counselor. Mr. O'Brien. I'm sorry, Mr. Kassar. My apologies.
May it please this honorable court. My name is James Kassar. I'm an attorney practicing with the Lotentio Law Group. We represent Daniel Lopez, plaintiff in this action for medical malpractice. Dr. Timothy Adams appeals from an order of the Honorable Justice Sampson, which denied his motion for summary judgment. And for the reasons set forth in the plaintiff's responding brief, the decision to deny summary judgment was appropriate, and therefore the decision ought to be affirmed. The underlying surgery itself in this case that Dr. Adams performed was a success. Nobody's arguing about that. It was successful insofar as the J pouch was created, which replaced the section of colon that had to be removed. What the plaintiff contends is that the subsequent injury from the compartment syndrome, which was caused by him lying in stirrups for over 8 hours without being repositioned.
And that's all laid out in your brief very well. The alleged change of theories, a new theory here in opposition to the motion for summary judgment. Do you want to address counsel's contentions on that issue?
It's not a new theory at all. It's in our verified bill of particulars that failing to properly reposition, and otherwise move the patient to maintain circulation was alleged to be a theory of liability here.
Where's the allegation of failure to position?
It's at paragraph 1H in the verified bill of particulars.
I think the question, as counsel stated, comes right down to the issue of palpation, and it's her position that you needed to talk about palpation at some time before your expert discussed it. Okay. Do you think that the law requires you to be so specific about the manner and ways in which you maintain that the defendant failed to maintain the proper circulation?
In rebutting the initial prima facie case that was made, we set forth a competing affidavit from our expert, which at that point maintained that the standard of care had not been met in this case. That includes palpating. Palpating is a part of the repositioning and inspection that should have taken place throughout the surgery.
And what would be the purpose of palpating?
Palpating would have discovered the potential for the compartment syndrome, which did eventually result. So the theory here being, at least, had he palpated appropriately, then the compartment syndrome would have been avoided.
What would the appropriate steps have been take if the palpation revealed some indications of this problem?
Well, I'm no expert, but I think it stands to reason that if one had palpated the patient and saw that the potential for the compartment syndrome was there, that they could have taken corrective measures before it got so bad, and that it worsened due to the negligence in failing to address the problem. So I think that this was appropriately addressed in response to the initial motion for summary judgment, which set forth the prima facie case. With a supporting expert affidavit, that our competing affidavit raised a tribal issue of fact, which was the finding of Judge Sampson, which is why his denial of the motion was appropriate.
As I understand it, Counselor, palpating is a diagnostic technique.
Right.
Right. And I think your position is you don't need to lay out every diagnostic technique that could have been used in order to prevent an injury in your bill of particulars. That's what makes this not a new or unique. You did lay out your theory in the bill of particulars that the physician failed to maintain, but the specific diagnostic technique may not have been in bill of particulars, but that's okay.
Yes, absolutely. In fact, the Valenti case out of the First Department says a party may even raise a completely unpleaded issue on a summary judgment motion so long as the other party is not taken by surprise. And I don't think that this was a surprising issue at all to be raised in opposition to the summary judgment motion.
Well, the defendant doesn't even believe that palpation is part of the standard of care, and the experts affidavit they submitted, they indicated that there's only two things that can be done: speed up the surgery and, provide proper cushioning. So it's not like it's part of their standard of care. So in a sense, the experts are almost disagreeing over what the standard of care is. And that has to be reviewed by a jury, would be your point.
Absolutely, Your Honor. Yes, that raises an issue of fact for the jury, is that we have two competing experts here, and that could not be decided as a matter of law. So that's exactly why the decision was correct. I would rest on our paper.
Thank you.
Thank you.
Case 836 is Hintu versus Evolve Technologies Incorporated, 836. Not confident I pronounced your client's name.
It's just two.
Yes, we have a recuser from Justice Del Conte, and appellant's counsel is remote. Mr. Cartwright, you may proceed.
Thank you, Your Honors. Good afternoon, and may it please the court. My name is Daniel Cartwright. I represent the appellant defendant in this matter, City of Utica, with respect to an appeal of denial of its motion to dismiss, which was pursuant to 3211A1 based on documentary evidence and 3211A7 versus based on failure to state a claim. Your Honors, I'll try to be brief. The underlying facts of this case are pretty straightforward. Halloween 2022, there's this stabbing at the Utica City School District. It involves an assailant who was able to gain entry of the school with a knife, ended up stabbing a student. Essentially, the allegations here are that a metal detector that was in place at the school failed to detect the knife, which allowed for the assailant to gain entry with it and commit the alleged crime or incident. So,
Counselor, I'm going to interrupt you right at the get-go just so I can get something straight in my head. And it's always interesting to me how things sometimes from a legal perspective look a little different here with the benefit of our ability to have time to look at the issues. But I'm looking at the agreement between the city and the school district. It's called School Security Officer Agreement. So This is broader than just providing school security officers at the medals. They're security officers, generally speaking. They don't, their function is not, I'm not trying to set you up the question, I'm trying to understand it. Their function is not limited solely to working the medals, correct? They have a more broader function according to the contract to provide for the security and safety of all students, staff, visitors, etc. That's one of the things they do, right?
Well, without parsing all those words into whether it's, how it affects legally this case, I would say that contract, it's a 2006 contract between the school district and the city. And it's essentially the school district saying, hey, we would like school resource officers on our grounds in the city, like many others around the country. Say, okay, we have off-duty police officers that we can release to you. Here's a contract.
Counselor, forgive me. I'm not trying to set you up with a tricky question.
Okay.
But the duties of the city police officers under this agreement is more than just the medals, correct?
Yes, it's essentially, be on site and perform all the functions that a school resource officer or school security officer would do in any other school around.
If there's a fight in the cafeteria, they respond. They're wearing police uniforms, city police uniforms.
Right.
They have the ability to make arrests and do all that, those types of things.
So, and the reason I gave you that introduction to my question before was looking at this now where the court addressed the provision about gross negligence. That's really vis-a-vis the relationship between the school district and the city. But see, what didn't get discussed anywhere, maybe I'm wrong about this, this strikes me as a classic Espinal case. That is where there's a contract, for example, between, a landowner and a snowplow driver. And, then you get the three exceptions to whether or not there's a duty, because your whole argument about duty is that they didn't allege a duty, and you moved under 3211A1, saying the contract negates the duty, A7, that they hadn't alleged a specific duty. But it seems to me if we look at this, then we have, the three things from Espinal, if that's how we're supposed to look at it, and that's my ultimate question. But, launch an instrument of harm, entirely displace or cause detrimental reliance to the plaintiff. So I know that's not argued, but I was having trouble grasping the argument about duty in your papers if I didn't apply Espinal.
Yeah, it's an interesting point you bring up, Your Honor. I wasn't the one who wrote the brief. I wasn't involved. Our firm wasn't involved even with the underlying motion, anything like that. This is a case that was handled by Corp Counsel up through briefing of this appeal. We only took it over after briefing. So sure, there's the Espinal argument, and there's others that I would say I would rely on if the case goes forward. But that's not what's at issue here and based on the record. So it's not something that, I can really fairly argue before the court today is alternative or other grounds by which this court should dismiss the city.
In fairness to you, go ahead, Your Honor.
I just don't know how this is not an Espinal issue. Did the city have a duty? And that's what we're talking about. And we have to look at the factors. Is that correct, or you're saying that's not correct?
I would agree with that, but it's not what was argued below, and it's not what's in the appeal. So it's not something that I can really argue before the court, having not given the court nor my opponent a chance to address that. I don't think that's properly here on appeal.
Sounds like that might be the focus of a future motion coming from you if you lose this appeal. That may be a fair surmise. But on the issues that you're talking about, you want to briefly talk about, there was a request to dismiss based on the plaintiff's failure to answer a question of why he sued the city here. Do you want to address that, or do you want to move on to your more substantive, realistic contention?
I would rest on that argument. I will leave that for the court's own analysis, and I would just focus my argument on the documentary evidence along with the overall failure to state a claim. I believe that issue is briefed.
And Mr. Carvey, just in fairness to you, I went down the Espinal path just because sometimes we have to fit it in categorically to a legal construct,
Yeah.
But with respect to your motion, what do you think are the preserved proper analysis based on this record for why you think there's no duty? And that is, what duty did you attack? If it wasn't,
Your Honor, I think the overarching position for the city is that it's a separate and legal distinct entity from the school district itself. So there's two separate legal entities here where, the school district is the de facto employer of any school security officer that would be on site that day. It would be responsible for doing any training, if any at all, with respect to this metal detector that's been alleged to have either malfunctioned or just failed to do the job as represented.
Let me stop you yet again. So that's sort of where I thought you were going. That is, the duty that you were, as I call it, attacking, moving against, was what you perceived in the motion papers for your prior counsel, that the duty was based solely in vicarious liability. That is, there was no vicarious liability, that there was no independent liability, and there's no vicarious liability. So I'm not sure where we come out on that, but does that even matter in this context, given Espinal? So I'm struggling with, how do we not apply the law as we understand it to be, whereas the duty that was moved against, that is, okay, we're a separate entity. All right, as a separate entity, you had no duty except to the to the school district, and yet that is not necessarily legally, not factually, but legally true.
I guess I would cast it a different way and just say that, here there is a municipality, the school district, that's alleged to be the employer of the school security officer that's on site. And any negligent acts or omissions that would have been present with respect to the school security officer on site would have belonged to the school district. The city of Utica, the only thing that it could have done here is it contracted with the school district to furnish off-duty police officers for its employment as on-site school security officers, for which it has no liability. There's no duty for it to do any of the things that the plaintiff has alleged, which is, the failure to train its school security officer on the proper use of this Evolve Technologies metal detector. That duty would have belonged to the school district and not the city of Utica. And merely the school security officer wearing the police uniform and badge, as it states in the contract between the school district and the city, does not rise to some level that would make it vicariously liable under some theory of respondeat superior. There's simply nothing that the city of Utica did other than contract with the school district to furnish an off-duty officer for its use as an employee if it wanted to.
Well, they did hire the police officers. They did hire them and train them in that regard, but I don't know if there's any allegations here about with respect to the hiring process. But we understand your argument on that issue. We'll take a really close look at it.
Okay, thank you, Your Honors. And I have nothing else to add, so I would just yield on the balance of my papers and request that you reverse the lower court's order and dismiss the action in my client's favor. Thank you.
Thank you, Mr. Cartwright.
Good afternoon. Good afternoon. I am Robin Zimpel, and I represent NE2, the plaintiff, respondent in this action. First and foremost, I would like to set clear that this is not just a metal detector. This is an artificial intelligence weapons detection system. And these officers were charged with using them to detect weapons on students as they enter the school. There is a lot of emphasis, I think, that needs to be put on the fact that these officers, well, counsel says the contract with the school district between the city is to provide officers, not just the person, the uniform and the equipment. They're in their uniform, full police officer uniform. They have their utility belt complete with handcuffs, sidearm, all of that. They wear their badge. They wear their name tag with their rank, their City of Utica Police Department rank. They are there in all intents and purposes as, well, they're there as security for the school, but visually, they are a City of Utica police officer. If you took an on-duty police officer and put them next to the off-duty police officer in that school and didn't know which one was which, you couldn't tell the difference.
How does that create a duty by the city? Certainly the school district has a duty to its students in loco parentis, whatever language you want to use, and maybe even a landowner, but put that aside. I think what your opposition is saying is you didn't rely or allege a duty. Yeah, you have those facts in your favor, but how do those facts create a duty in negligence or other theory that was breached? It's all about the duty according to them.
I'm glad you asked that. I believe that it's clear that the fact that they're in their uniform with their utility belt, doing the jobs that they're doing at the school is also furthering the interests of their employer at the same time, the City of Utica, that is, furthering the interests of the employer, which is promoting the city, promoting involvement with the community, engaging and making sure that the community is safe.
Irrespective of the contract.
Irrespective of the contract. And I think the contract is not clear. And I think it's abundantly clear to the court, or it should be, that the city of Utica knows it's not clear too, because it had to provide 3 affidavits to try to establish a documentary defense. Because the documentary defense they're alleging, which would utterly dispute the plaintiff's contentions, is not sufficient to utterly dispute the plaintiff's allegations. And in the reply brief, the city makes point that the plaintiff does not contest the facts that are enclosed in those affidavits, because those affidavits should not be considered by the court at all on a motion under 3211 1A, documentary evidence.
Well, when they do submit evidentiary proof, the analysis goes, as you probably know, from whether or not you've stated a claim to whether or not you have a claim.
Yes.
And I think that's what they're really attacking, say you don't have a claim because you haven't alleged a duty that was breached.
Well, I also want to point out that the lower court didn't deny the city's motion with prejudice. It's without prejudice to allow for discovery, and the city can renew. I do believe that the plaintiff is entitled to discovery to look at how much oversight the city of Utica has while these off-duty officers are engaged in their school resource officer job. And I think we need to also be able to explore what their job description was with regard to these artificial intelligence weapons detection systems as well.
So you think the court got it right, and we may be back here on another motion, maybe not, but the case should proceed.
I do believe that the lower court got it right. We are entitled to discovery, limited discovery even, just to to look further into the engagement between the city and the school district and what these officers are doing. They're not just working the detectors at the door. They're supposed to maintain a visual presence as well. And whether they have officer duties that are separate and distinct from other types of resource officers, like the ability to effectuate arrests as officers in the school, as security officers in the school.
Thank you very much.
Thank you.
Okay. But yeah, he just dropped off the computer, I guess. 837 is Courtroom versus Erie 2 Chicago for Cattaraugus Board. The pro se appellant is submitted. Mr. Ferrandino, you've been very patient, and we welcome you here today. You are welcome to make your argument. We could point out at the outset that it doesn't appear that any appeal lies from the denial of this type of relief. Is there anything you want to add further that's not in your brief?
No, Your Honor. There was a lot of interesting argument today, so it was definitely worth the drive. But I appreciate that, and I would just say, Your Honor, that this litigation has been going on for 22 years. And at some point, it has to end. And I hope that it ends today.
All right. Thank you very much.
Thank you.